Court officer.
ಹೇಳಿ ಸರ್.
ಇದಕ್ಕೆ ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ ಏನಕ್ಕೆ ಯಾವ ವರ್ಷ wait please wait for some after 2 or 3 weeks let us see 2 weeks let me at least come up to 2009 I'm still struggling with 2007 after 2 weeks you move I'll give you a date application can you move after 2 weeks move after 2 weeks I'll give you a date because I'm not able to touch the daily hearing list also even if I give you a date I am not able to touch see the problem is if you are ready the other side won't be ready if both of you don't come nothing is going to happen after 2 weeks you please make a mention I'll give you a date in application ಏನಿದೆ recalling ತಾನೆ which list get list let us say I don't think it will reach I don't think it will reach today I have a Dharwad bench matter list ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ please wait that's hearing in the air please wait mostly what reach agala
Milad, on submission, Milad.
yes
Serial number 35, Milad. Milad, in that I have filed my wakalat for respondent number 1. RSA, old matter, Milad, 2006 matter. but my name is not shown, my lord. Better, my lord, in that we fear that there is an impersonation of respondent number 1.
Number 35.
I am for respondent number 1, my lord. It is showing as Kumar Swami for R1 anta torsta ide. But myself is Jagdish. We have filed a wakalat. We came to know recently only regarding the case. When the civil suit came to be filed by the very same.
Day after tomorrow. Day after tomorrow. Shri Jagdish as appearing for R1. Since it is stated that he has entered approval. Day after tomorrow.
Much obliged, my lord.
ಏನ ಕಾಂಪ್ರಮೈಸ್ ಇನ್ ರೀಕಾಲಿಂಗ್ ತಾನೆ? Yes. How are you? Enter there. Paragraph 4. It is after receipt of summons I got inquired. पता नहीं. ನಾವು ಫಸ್ಟ್ ಆಗ್ತಿರೋದು ಕಾಂಪ್ರಮೈಸ್ ತಪ್ಪು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
ಈ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಬೇಕಾದ್ರೆ ಅವ್ರು ಕೊಡ್ಬೇಕಲ್ಲ ಕಡಿಮೆ ಇದೆ. ಈಗ
ನೀವು ಹೇಳೋದು ಈ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಅವ್ರಿಗೇನ್ ಕೊಟ್ರಿ ಹೇಳಿ? ಶೆಡ್ಯೂಲ್ ಸಿ ನಾ? ಶೆಡ್ಯೂಲ್ ಸಿ ಅಲ್ಲಿ 5 ಐಟಮ್ ಇದೆ. 5 ಐಟಮ್ ಇದೆಯಾ? ಎಲ್ಲ ಸರಿ ನಂಬರ್ಸ್ ತಪ್ಪಾಗಿದೆ. ಯಾವ್ದು? ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಹೇಳಿ ಯಾವ್ದು?
160 ಅದು 11 ಆಯ್ತು. ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಇಲ್ಲ ಇದು 116/2 ಸರ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? 15 ಎಷ್ಟು ಗುಂಟೆ ಇದು? ಎಷ್ಟು ಗುಂಟೆ? ಎಕ್ಸ್ಟೆಂಡ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಸರ್ವೆ ನಂಬರ್ ಮಾತ್ರ 11/5 ಆಗಬೇಕು. ಆಮೇಲೆ 256
ಕರೆಕ್ಟ್ ಆಗಿ 15 ಗುಂಟೆ ಇದೆ. ಅದಕ್ಕೆ ಪ್ರಾಪರ್ಟಿ ನಾವು ಇಂಪ್ರೂವ್
ಮಾರಾಟ ಮಾಡಿದಾರ? ಇವ್ರ ಡಾಕ್ಟರ್ಸ್ ಅಲ್ವಾ ಇವರು? 3 ಇಲ್ಲ 3 265/4 ಅದ್ರಲ್ಲೇ ತಪ್ಪಿದ್ಯಾ? 265/4 and 265/5 ಇಲ್ಲೇನು ತಪ್ಪಿಲ್ಲ.
ಐಟಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ 11/5 216 ಆಗಿದೆ.
ಎಕ್ಸ್ಟೆಂಡ್ ಸರಿ ಇದೆಯಾ? ಲಾಸ್ಟ್ 390 ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ
ಐಟಮ್ ನಂಬರ್ 4 ಇದೆ. ಅದು 216 ಆಗಿದೆ.
ಕರೆಕ್ಟ್. ಆಮೇಲೆ ಐಟಮ್ ನಂಬರ್ 5
ಇದು ಐಟಮ್ ನಂಬರ್ 5 ಮೆಜರ್ಮೆಂಟ್ ಪ್ರಿವಿಯಸ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಹೌಸ್ ಅವರೇ ಕೊಟ್ಟಿಲ್ಲ, 8 ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವೇನು ಪಕ್ಕದವ್ರಿಗೆ ನಾವೇನು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ವಿ ಇಂಡಿಪೆಂಡೆಂಟ್ ಏನೇನು ಅವರೇ ಇಲ್ಲ. ಮೆಜರ್ಮೆಂಟ್ ಕಮ್ಮಿ ನಾವೇನು
So if what he says is correct, if the survey numbers are changed by consent, your problem should be solved. ಎಲ್ಲಾರನ್ನ ಕರ್ಸ. Okay. If both of you agree, I will record his statement that surrender number 116/2 actually refers to 11/5. Similarly, 256 refers to 265, 11/5 refers to 216. To that extent, the compromise will get modified by virtue of consent.
That is,
Okay, please satisfy yourself. Else I told you what I thought about the problem.
and with regard to the here,
Please verify. Day after tomorrow. ನೀವು ದಯವಿಟ್ಟು ಬನ್ನಿ ಕೇಸ್ ಕರೆದಾಗ ಎರಡೆರಡು ಸಲ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ ನಾನು ಅಲ್ಲಿ ಯಾರು ಹೇಳಿದ್ರು ಅಟ್ಲೀಸ್ಟ್ ನಾನು ಏನೋ ಮಾಡ್ಕೊಳ್ತೀನಿ.
As far as the serial number 1, my name is being shown in the this thing.
ನೀವಿಲ್ವಾ ಈಗ?
ವಕಾಲತಿ ಇಲ್ಲ, ಅವರು ವಕಾಲತಿ ಇವಾಗ ಜಗದೀಶ್ ಅಂತ ಅವ್ರು ಹಾಕ್ತಿದ್ದಾರೆ.
Presented up the appellants, the name of CM Desai and Arvind C. Desai be deleted from the progress.
Much obliged.
That's all. Then who's alive? Almost everybody is dead then. Respondent 1A and B are dead according to you. 1A, 1B. Who was respondent number 1 in the trial court? He was a defendant. What has happened in the suit? Now, both the LRs of the both of them are dead, then and appeal against R2 is also abated. R3, R4. When did they die? You have any idea when did R3 and R4 die? It is stated in the memo filed by the counsel for respondent number 5A, B, 6 and 7 that R1A died about 5 years ago and R1B over both the LRs of the original first defendant KG Chandrasekharappa is also dead, are all dead. It is also stated that respondent number 3 and respondent number 4 are also no more. The memo was filed on 5th of April 2021. It is nearly 2 years ago. Since no steps have been taken against R1A, R1B, R3 and R4, the appeal against them stands abated. How are they related to the plaintiff? Brothers, huh? How are they related to the specific performance suit? Who was the person who executed the agreement? Then the appeal would not survive, madam. Madam, who is Basurajappa? Which defendant? Which defendant? Which respondent?
There is not very.
1 minute.
First one is Chandrasekhar Rao, brother.
So if Chandrasekhar had succeeded to the estate of Basurajappa, and even if he is dead, his LRs are also dead, then the appeal would stand abated. Because they are the persons to execute the sale deed, isn't it? Who has received? Who has received? Correct. But since you have not brought them on record, their LRs on record, then the appeal would abate.
Just one big time.
No, it's already abated. It's like 2 years ago, it's abated. And according to his memo, R1A died 5 years ago. And the memo itself is dated 21. I'll hold that the appeal has abated. Whenever you take steps, it come up. This appeal has been filed against the judgment and decree of the trial court, by which the trial court has refused to enforce the agreement of sale executed by KG Basurajappa. The original defendant is the brother of KG Chandrasekharappa, who stated to have succeeded to the property on the death of Basurajappa. Since no steps have been taken against the LRs of Chandrasekharappa, the suit for special performance would naturally abate, and consequently this appeal would also stand abated. Whenever you make an application, let us.
Number 3, Jagdish. Jagdish.
When did R4 die? When did R4 die? What is the suit for? On 6/6/2022, on 25/2/2020, it was reported that respondent number 4 had passed away. No time has been granted to take steps. Until today, the LRs of R4 are not brought on record. Consequently, the appeal against R4 stands abated. One minute, let me go through the letter. Yes. No, I'm concerned with the letter. For this reason, I had asked the registry to tell us whether we received a communication.
I'm only taking objection.
Registry has received letter dated 11/10/2022 from the Ashok Nagar, from the police, from the sub-inspector of Ashok Nagar police station, whereby he is requesting for the original documents that have been produced in OS 25795/2011. Original documents that is stated to be a GPA, affidavit, sale agreement and sale deed. They stated that
No, I think 25795 is still pending in here. He wants the and submitted a registration.
yes, and whereby he is seeking for original documents, that is the GPA, affidavit, sale agreement, sale deed, which have been produced in RFA 402/2008, that is the instant appeal, for the purposes of further investigation. And view of the said request, registry is directed to hand over the aforementioned documents after retaining a color Xerox copy of the said documents. The sub-inspector is directed to retransmit these documents immediately on the conclusion of the investigation. Hmm. I'll impose 10,000 rupees on both of you now.
His counterclaim is based on.
Next Monday ಹಾಕೊಳ್ತೀನಿ, ಏನ್ ಮಾಡ್ತಾ ಮುಗಿಸ್ಕೊಡಿ. Be fair to me, 2019 4,000 rupees cost. ನಮ್ ಸಾಹೇಬ್ಗಳ ಕಾಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟು ನಾನು ಬೇಡ ಅಂತ ಅಂದ್ರೆ ಅದು ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. Where is the letter of that forensic department?
This 12/4/2016. Number 27/6.
One minute. 24/3/16. Which is the first letter? 12/4/16. 12/4/16. Huh? Original ಕೊಡ್ತೀರಾ? You know, see first order, directing the matter to be referred to.
Internal page 7 of the order. Second order.
On 18/3/2016. This court had referred exhibit D to the alleged will stated to have been executed by Srimati Meera Narayan and exhibit D19. The registered sale deed executed in favor of Srimati Meera Narayan for the purpose of scientific examination and for furnishing of opinion as to whether the signatures appearing on exhibit D2 stated to be that of Srimati Meera Narayan tally with the signatures of Srimati Meera Narayan appearing on exhibit D19 registered sale deed. The director of the forensic science laboratories by letter dated 12/4/16 had opined that for the examination of the signatures in the alleged will dated 14/11/1998, only one admitted signature executed during the year 86 had been provided, which would be insufficient for examination and for accounting for the variations due to the time gap. It was therefore requested to forward 5 to 6 admitted signatures of Meera Narayan executed in the period 1998. Next. By another letter dated 27/6/2017, the director had stated that his request for sending the admitted 5 or 6 admitted signatures of Meera Narayan was not complied with, and hence he was constrained to return Exhibit D2 and D19. An application is thereafter filed by the Appellant's Counsel seeking for a direction to Canara Bank to produce the savings bank account with respect to the account maintained by Meera Narayan in that bank, and also the checks issued by her. On 23/1/2023, this court had directed to P.P. Mutana to take notice on behalf of Canara Bank and make his submissions. It was also ordered that we should secure the records that were sought for in IA 1/18. Today, Shri P.P. Mutana, Tenant Counsel, appearing for Canara Bank, has filed a memo stating that he has procured the application form by which Srimati Meera Narayan had sought for opening of a non-residential external account and also the statement of account. Statement of account then ಬೇಕಾಗಲ್ಲ. ಅಲ್ಲ, ಅವ್ರಿಗೆ ಸಿಗ್ನೇಚರ್ ಬೇಕಿರೋದು ಅಷ್ಟೇ. Third counsel submits that the bank is not in possession of any checks or withdrawal slips, and in order to substantiate the same, an account statement has been produced which indicates no transactions. In view of the learned counsel also submits, file ಮಾಡಿದಿರಾ ಇವಾಗ ಮಾಡ್ತೀರಾ? Learned counsel undertakes to file the original of the application form which had been submitted by Srimati Meera Narayan in the registry today. The office is directed to send this original application form to the Director of Forensic Laboratories and request him to render his opinion as ordered on 18/3 alva 18/3/2016. The appellant is also directed to pay the examination fee of rupees 5,000, which is required to be deposited in ಕೊಡ್ಬೇಕಂತ. It is submitted that our brother, in case the document of this case is again sent for examination, then document examination fee of rupees 5,000 may be deposited in the head of account. 5,000. 5,000 in the head of account. In the head of the account, as indicated in the letter dated 27/6/2017. The office is also directed to send Exhibit D2 and D19 along with the application form. ಮಾಡಿದಿರಾ? Council submits the need to be done today, office to verify. It is stated within office to verify. Yaar is standing counsel? Who's the standing counsel? Power transmission. APC only. She so and so is permitted to take out note, to take notice of behalf of respondents 1 to 6. Or is it good? Once he takes notice, he takes notice. Is it good? Weak step. Pass it over. Complete reason. Maintain the model. What is the mistake that is corrected according to you? Yardo? It was mentioned as Metropolis Subramaniam. Yesterday and the appellant is Subramaniam. Ayestra correct agidya. Our ತಂದೆ ಹೆಸರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳಿದ್ದು ಮೆತ್ತುಪಳ್ಳಿ ಸುಬ್ರಹ್ಮಣ್ಯಂ. ಇದು ಶ್ರೀನಿವಾಸಲು ನಾಯ್ಡು ಆಗಿರ್ಬೇಕು. Who's the second plaintiff? She is power of attorney holder. Represented by a power of attorney holder. How are they related? Then what is the suit for? I'll allow him to correct it. It is stated that an error had crept in while indicating the name of the plaintiff's father. It is stated that instead of stating that the plaintiff was the son of Srinivasulu Naidu, it had been wrongly stated as son of, that he was the son of Mettupalli Subramaniam. On 16/1/2019, the council was permitted to get the mistake rectified. In my view, since this is a minor error, it would be appropriate to hold that the name of the description of the plaintiff was wrongly stated and it should have been stated as Subramaniam, son of Srinivasulu Naidu. As a consequence of this order, the trial court is directed to amend the cause title, and the counsel for the appellant is also permitted to make necessary corrections in the cause list. Yenagide adu appeal? ಏನು ಎಂಟ್ರಿ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ? Which are the numbers connected notice? Post along with RFA 1769 of Sixth day, main is the objections. Nodidara. Court fee ಎಷ್ಟು ಕೊಡ್ಬೇಕಿತ್ತು? I think you can do it ಎಲ್ಲ ಇವತ್ತೇ ಮಾಡಬಹುದು. It's the last chance. A week's time is granted to complete the job. Yes, sir.
My lord, serial number 15, is it?
16.
My lord, serial number 15, my lord, to take steps to LRs of R4, my lord. My lord, this court be pleased to direct the respondent to give the addresses, my lord. I will take necessary steps in this case, my lord.
I will hold that the appeal is abated whenever you are ready. Why is he obliged to give you who's dead now?
My lord, R4 is dead, my lord. R4 is dead. They
The office,
intimated.
madam, the office objection is date of events to be arranged chronologically. Counsel to sign the synopsis. Executant's name to be stated in the capitals below the signature. Actual number of delays to be stated. I have one affirmative probabilistic. This has not been done. Those 7 adjournments have been granted.
My lord, I will do the needful, my lord, then.
I will call it at 4:30. Do it by then. Because all of them are doable. You don't need the party's presence for this.
My lord, 2 days time may be given, my lord. I will do the needful, my lord.
You will forget.
No, my lord, no, my lord. I will
4:30.
definitely do. I had intimated the parties also with regard to give the LR's details, my lord. They
That
said
is
that they
afterwards.
do.
That is afterward. This is got nothing to do with the party. It's for you to do.
My
It
lord,
takes
2 days
5
time, my lord.
minutes.
I will definitely do the needful, my lord. Just 2 days time.
2 days time is granted. Finally.
Much obliged.
ಬೇರೆಯವರೆಲ್ಲ ಸಬ್ರದ್ ಅವರೆಲ್ಲ ಇದಾರಲ್ಲ. What was the suit for? ಇದು ಅದೇ ಅವ್ರು ತೀರೋಗಿದ್ರು ಅವ್ರ ಮಗ. Not very. No, but there was a writ petition filed in 2013. You are aware of that. You are aware of the death of your counsel. You had entered the matter to Rakshan. Then this appeal was disposed of when? 11 years you want, what would have happened in the meanwhile? ನಿಮ್ಮೇಲೂ ಹಂಗೆ ಹೇಳ್ತಾರೆ, ನಮ್ಮೇಲೂ ಹಂಗೆ ಹೇಳ್ತೀರಿ. ನಾವು ಒಂದು ಹೇಳಿ ಹೇಳ್ತಾರೆ. Issue notice on IA. It is stated that Sri H.K. Keshavamurthy, counsel appearing for R3 and R4, no more. Is no more. Issue court notice to respondents 3 and 4. A1, something should be considered along with the main matter. Post for hearing 1 next week on the 6th. Notice ಹೋಗಿದ್ಯಾ? ಸರ್ವಾಗಿಲ್ಲ.
ಅಷ್ಟೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿ.
ಯಾರು ಅಪೇರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಸರ್ವ.
You can't not take notice for R4 F. ಏನ್ ಮಾಡಿದಾರೆ? A to C ಅಷ್ಟೇ. D E served. She submits that he has entered appearance for R4 F also. Thus, it is clear that all the applicants in IA number 6/2022 are served and some of them are represented. Since the right to sue survives, the delay in filing the application, the application filed to set aside abatement and the application filed to bring the laws of the deceased R4 are allowed. Cost rate will be amended. Post for hearing. Date code 1 second. ಏನಕ್ಕೆ ಬಂದಿದೆ ಇವತ್ತು? Hyderabad is club, no?
All the appeals cases. First matter is respondent.
Yes, first appeal 972 is filed against which order?
Filed against the order.
Raising out of a suit.
Suit of person performed. The director of petition
Order of the daughter of whom the plaintiff or defendant in that suit. Sudha. Sudha's daughter is as filed a suit for partition. And Sudha had executed an agreement of sale. What has happened now? Sudha's suit decrease. So to the extent of Sudha's share, it will be valid. To the extent of her share, it won't be valid. You are now for Sudha. When do you want it? Post for hearing on it. In the appeal, suit is for ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದಾರ. One other suit filed. ಯಾರು ಹಾಕಿರೋದು?
Certified copies of art in US of the identical art production.
This is a suit for injunction. That is a suit for declaration. I'll direct the document for return. An application is filed seeking for return of exhibit P1 so as to facilitate the plaintiff, the appellant, to produce the same in OS 973 of 10. ಅದು ಎರಡು ಕ್ಲಬ್ ಆಗ್ಲಿಲ್ವಾ ಅವಾಗ? 973/2003. since the production of this document would be essential in OS 973/2003, office is directed to return Exhibit P1 after retaining a certified copy for the record. He is accordingly disposed of. Interim order granted earlier, to stand extended. The name of Shri Mrs. Kamal and Banu and MS Purushottam be deleted from the cause list. IA 3/2011 for additional grounds and IA 1/2030 should be considered along with the main appeal. Isn't Prasad sir? Come madla. Hello madla, batra. Since the right to sue survives to the applicants in IA 1/2022, it will be necessary to condone the delay and also to set aside the abatement and permit them to come on record. So accordingly, IA 1 to 3 of 2020 is allowed. Cost rate will be amended. ಎಲ್ಲಿದೆ ಇಲ್ಲಿರಲ್ಲ ಅವ್ರನ್ನ ಆಫೀಸಲ್ಲಿ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ. ಮಾರ್ಚಲ್ ಒಂದು right to sue survives. 1/2022 is allowed. First rate will be amended. In including Tenant.
Number 25.
As requested, notice to RP is dispatched with the risk of the appellant. Post for hearing April on date.
Number 26.
Suit was filed by whom? Suit was filed against the respondents 3, 4 and appellants. Appellants 3, 4 and respondent number 2.
There was some other
Suit is filed against whom? Who are the defendants? That is, R3 and R4 are represented by
Society. They enter into compromise. Complete fraud develops. Again, reference to.
Is that a fact? Is it a fact that our A3, A4 were represented by a power of attorney holder who had entered caveat through the paid secretary? Is it a fact? No, we'll condone the delay, then let us see. That review is filed against which order? Where is that order of remand passed by this court? Let us see that. In the first appeal that was filed by the society, were you represented?
Bharat Kumar is the paid secretary of the society. I am not.
They are challenging a compromise simply on the ground that they were not represented in person. They were represented by a GP holder who incidentally happens to be the secretary of the plaintiff himself. So how can you expect? No, I'm only concerned with the fact that if he is a paid secretary, basically you are filing a suit against yourself and getting a compromise. Who has filed the review? Who has filed the review, Chayasiki? But either way, in my view, that review may have become infructuous by virtue of the compromise that is now entered into. Now, this will be the basic appeal because it's against the compromise that they have prepared an appeal.
Can you say this? It contains DPO order.
No, I'll take it up. I'll condone this delay and I'll take it up. Is to put the records of RP. So on. Post along with RP numbers. So on. Next one. There are R3 and R4 here. The application is noticed that R3 and R4 were placed ex parte in the trial court. In view of the above, notice to them would be unnecessary. So, consequently, the application filed. But if they have served and they remain, CPC is there a provision. If they have chosen not to appear, notice to them dispensed. Consequently, IA 1/2022 is also dismissed and unnecessary. Plus 15, allied moves. What direction? Suit for your what is the property? What is the difference? They set up a will. What is the rent that is? Then where is the question of depositing the rent? That we can always give you, isn't it? But you're only interested to get the possession and then mean profits, isn't it? No, but since you're enjoying the property, how is it related? How is the rent related to? Natesh is the son of Narayan, and dependent is siblings. Angarellaru, 3 jana gandu makkalu.
The second son is given the first floor and ground floor.
ಇಲ್ಲ ತಾಯಿಗೆ ಏನು ಕೊಟ್ಟಿದ್ರೆ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್. ಗೋವಿಂದರಾಜ್ಗೆ ಜಗದೀಶ್ಗೆ ಗೋವಿಂದರಾಜ್ಗೆ ತಾಯಿಗೆ ಥರ್ಡ್ ಫ್ಲೋರ್. ನಿಮ್ಗೇನು ಕೊಟ್ಟಿಲ್ಲ. Has he said anything in the will as to why he has not given it to you? ಯಾವ ಜನ ಇವರು? Married to whom? Whom did you marry? How old are they? What do they do in Kelsa? What is your client do? That money that they have taken would have been spent by now. And yeah, I think this application is spent only to coerce them into some kind of ನಿಮ್ಗೆ ಗೊತ್ತು ಅವ್ರ ಕೈಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ ಕಾಸನ್ನ ಅಂತ, ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್. $26 lakhs. 27 lakhs. This is in respect of second floor ಏನಾಗಿದೆ? ಯಾರು ವಾಸ ಇದಾರೆ ಅದರಲ್ಲಿ? ರಿಲೀಸ್ ಆಗಿದೆ. ಡಿಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಸೆಟ್ಲ್ ಆಗತ್ತಾ? ಮಾಡ್ತಾರಂತ. Total is what? 13 lakhs and which is the other portion? Yes. $15 lakhs.
52 lakhs.
No, then that time you make an application, I'll permit you to return. This appeal arises out of a suit for partition filed by N. Natesh against his mother and 2 brothers. In the suit, Natesh sought for partition. The premise that the suit property was his father's property and that he had died intestate. A defense was set up that Natesh's father had executed a will, and as a result of the bequest, the defendants had succeeded to the property. The trial court has refused to accept that a will had been executed in favor of the defendants, and it has decreed the suit, granted 1/4 share, 1/3, 1/4 share to Natesh. In this appeal, an application is filed to direct the defendants / appellants to deposit the rental income that is being derived from the first floor of the suit premises. Objections are filed stating that the first floor and second floor have been leased out by accepting a sum of rupees 15 lakhs, 13 lakhs 50,000 and 13 lakh 80,000 under unregistered agreements, and no rent is being received. It appears that the property has been mortgaged for the aforementioned sums, though without there being a registered mortgage deed. In my view, since the trial court has held that the bill had not been proved, the share of Natesh cannot be enjoyed by the defendants exclusively. Therefore, be necessary to direct the respondents 2 and 3 alva, appellants 2 and 3. Tayen boge mandila alva. Appellants 2 and 3 to deposit sum of rupees ಎಷ್ಟಾಗುತ್ತೆ? ಎಷ್ಟಾಗತ್ತೆ ಅವಾಗ? 14 lakhs. And for 52, yeah, divided by 4 is 13 lakhs. Directed to deposit. Appellants 2 and 3 are directed to deposit 13 lakhs for this court within a period of 4 weeks. So on such deposit being made, this amount shall be invested in a fixed deposit. It is made clear that in the event the persons in possession of the property on the basis of the amounts given to the appellants intend to vacate the property, liberty is reserved to the appellants to seek for modification of this order. Seventeen. After 4 weeks, let us see. I am now considering appeals in which third generation. April only.
April 10th.
Section of land.
Please loud about the
This appeal has been filed challenging the rejection of the plaint, challenging the order by which now then in what way it is relevant for deciding the suit. If it is relevant to this in this suit, There is an order in his favor in respect of 15 quintas. This is another. The plaint was rejected. Nayatullah. Second judgment you have the Jharkhand. In both the cases, it is not a case of rejection of the plaint, isn't it? In both the cases, it is not a question of rejection of the plaint. It's a question on the merits of the claim. No, that is on the merits after the court had decided this order has been passed. But that can't be a ground for rejection of the plaint. A. Venkatesh, the plaintiff, A. Venkatesh instituted the suit seeking for a decree of injunction in respect of property bearing BBMP number 1, old number 19/1, which is situated at Rahman Nagar, RT Nagar, Bangalore. It was this case that this property was carved out of serve number 19/1 and belonged to Nagarajappa's family. And Nagarajappa had adopted him, and on the death of Nagarajappa, he had succeeded the property on the basis of a villa. What is this? I'm not able to. Is adopted the plaintiff, and in the partition it was mentioned that this is property. Belong to the Nagarajappa's family. And in a partition effected on 11/3/68, it had been acknowledged that he was the adopted son, and on the death of Nagarajappa, it would devolve onto him. It was stated that on the death of Nagarajappa, he had succeeded the property, and when he tried to construct on the property, obstruction was caused, and hence he was constrained to issue a notice, and thereafter also issued the suit. The Union of India entered appearance and contested the suit. It was their case that the property belonged to them and that they were using the property for military training. It was also, I'm only narrating the facts as stated. It was stated the ownership of the property had been recognized. It is also stated that there were old dilapidated buildings in the suit property, and permission had been sought for from the higher authorities to demolish the same. and permissions had also been granted in this regard. It was stated that the property belonged to the Ministry of Defense, and a joint survey had also been requested. And during the course of the joint survey, it had been discovered that certain persons had encroached upon the property, and as a consequence, proceedings for evicting them under the PP Act had been initiated. It was stated that in view of the above facts, it would be impermissible for Venkatesh to file a suit for bare injunction. Next, the trial court by the impugned order has come to the conclusion that the evidence on record indicated that the defendants had filed eviction petition under the PP Act, and the same was pending before the competent authority. It has observed that Venkatesh had not produced any material to show that no case was pending before the estate officer. And it has also held that no documents had been produced to show the old serial number, that is serial number 19/1. The trial court has ultimately stated that in view of the documents produced by the defendants, and in view of the fact that proceedings are pending before the estate officer, the plaintiff could not be permitted to seek for injunction by filing a suit for bare injunction. Tenant counsel for the appellant contended that the trial court could not have rejected the plaint on the basis of the documents produced by the defendants and on the contention raised by them that cases were pending under the PP Act. He submitted that in order to reject a plaint, the court could look into only the plaint governments, and it could not reject the plaint by considering the defense of the defendants. Tenant counsel for the defendants, the other hand, contends that the impugned order is just and proper. It does not suffer from any consequence, from any defect. He also sought to rely upon the judgment rendered by the Supreme Court in Anatullah Sudhakar and Jharkhand State Housing Board to contend that the suit for injunction was not maintainable. It is settled law that in order to reject a plaint, only the averments made in the plaint would be germane. It is equally well settled law that the defense of the defendants or the documents produced by them would be of no relevance to consider the question of rejecting the plaint. Admittedly, in the instant case, the trial court has not rejected the plaint on the basis of the plaint averments, and the plaint has been rejected only on the basis of the contentions taken up by the defendants. The impugned order is therefore unsustainable. The learned counsel for the defendants, however, relies upon the judgments referred to above to contend that a suit for injunction is not maintainable. In the above said decisions, the Supreme Court has held that whenever a cloud is raised in the title of the plaintiff, it will be necessary for the plaintiff to file a suit for declaration. It is also stated in the very said decisions that merely because contention is raised by the defendants regarding the title, that would not by itself result in the suit not being maintainable. Be that as it may, in both the cases, the court was not considering the question as to whether a plaint could be rejected on the basis of the averments made in the written statement. that you matter, for the purpose of this appeal, the said judgments would have no applicability. As the impugn order has been passed only on the basis of the defense taken by the defendants, the same would not be sustainable. Accordingly, the impugn judgment and decree is set aside, and the matter is remitted back to the trial court to consider the suit on merits. It is made clear that this court has not expressed any opinion on the merits or demerits of the case of either of the parties. Reason stated in IA 3/2018 delay of 9 days in filling the case number. The application filed for withdrawing the suit is requested to be dismissed as not pressed. Accordingly, IA 2/18 is dismissed as not pressed. In suit,
But the position I have got it right.
really strong. Thousand 300 days. Two weeks.
So everything.
Enough? ಇನ್ನೊಂದು ರಿವ್ಯೂ ಹಾಕಿದ್ರ You are the petitioner ಅಲ್ವಾ? ಇನ್ನೊಂದು ರಿವ್ಯೂ ಹಾಕಿದ್ರಾ? Post along with RP number so on. ನೋಡಿದ್ರ ಮೇಡಮ್? Circular is only giving effect to the amendment ತಾನೆ. No. I'm not on the circular. Circular is only a reflection of the amendment. If under the impugn order, what is the order that is passed? So how do you maintain an appeal under which provision of law you maintain? Tell me if you have to file a first appeal. Under which provision can I say that this is an appeal under? How? A judgment allow. Show me from the provision of law. No, first CPC ಅಲ್ಲಿ an order. That is not the substantive provision which gives you right to prepare an appeal. That High Court rules are framed to give effect to the substantive right that you have to prepare an appeal. So you will have to show me. Right. Let me not repeat the same mistake if it's a mistake. Unless you are to show that you have a right of filing an appeal against an order passed under order 21 rule 32. This appeal can't be entertained. You may file a writ petition, but until a specific provision is granted, giving you the right to prefer an appeal against an order passed under order 21 rule 32, the appeal would not be maintained, notwithstanding the classification. No, I will consider it under section 47. Even if it's under section 47, unless there's a provision giving you a right of an appeal against an order passed under section 47, you cannot prefer an appeal. There must be a provision CPC which says that you have an appeal against an order passed under section 47. We'll ignore the clause that is used by you. We'll assume it is traceable to section 47. Against such an order, how do you say that an appeal is maintainable under section 96? Because 96 only is an a decree. As against an application filed under order 2199, there is a specific provision saying that it will be treated as a decree. So hereby, and there's no deeming clause, and the deletion of this from section 2 would not render you to file an appeal. So you may have to challenge this order by filing a writ petition. If you want, I'll pass an order. I don't need a memo. Because it will help our office to decide this issue, because they are being forced to register it as an execution first appeal whenever an appeal is filed. So if there's an order saying that no first appeal is maintainable against an order passed under section 47 or against an order dismissing an execution, then they will return it on the ground that is not maintainable. So there will be some clarity for everybody else. Tomorrow. ಟೈಮ್ ತಗೊಂಡ್ರದು ಕುಮಾರಸ್ವಾಮಿ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ, ಬೇರೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬೇರೆ ಯಾರೋ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ವಿ, ನಾವು ವಕಾಲತ್ ಹಾಕಿದೀವಿ, ನಮ್ಮ ಹೆಸರು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಏನೋ ಹೇಳಿದ್ರು, ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. ನಾಳಿದ್ ಬರುತ್ತೆ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಏನಾಯ್ತು? Wednesday. Brother and sister. They don't want you to interfere with their property.
One schedule C property. They have given a proposal that the A and B sisters. But that one opposition in that is A and B can partner with the. That we are asking is that whether these sisters will take the security.
No, but if he succeeds on the ground that this property is purchased by him, they're raising a loan.
That will be the same market. Condition there will be.
So instead of 1/5, why don't you pay him something so that he gives up the right in respect of that property? He will retain his property. You don't have to pay the exact 1/5.
We had a discussion that the stock. Wait and
So by piece, why? Because 1/5 of from whatever was told last time, it's about 1.3 crores for both the properties. So he'll be entitled to 1/5 of that amount, theoretically speaking. You give him a figure which is reasonable, he may accept without there being any. Whatever is the proposal, it should be worked out.
Schedule B property. What it suggests is, you can give the schedule B property.
And he keeps C schedule. I think that is also fair enough. No, schedule B, he's saying he'll give up 50%. So when do you want? Friday. Monday. Mother father joint will then. Mother has sold the property. Friday. Six. 8. No. Good for. ಬರೀ ಈ ಶೆಡ್ಯೂಲ್ ಒಂದನ ಏನ್ ಈ ಶೆಡ್ಯೂಲ್ ಏನು
Number 161.
One, so number 160,
161. Number 161. 1 acre 35 units. Moving to floor bar 4. 1 acre 1. The 183 bar 2. 1 acre 1.
Malakatam. Suit for declaration, declaration. Suit for declaration as to what?
The building one of the people. Also for common. Here three sons. Koredola, Intamadera, Teluga, yes.
Chelvam. The relationship is not in dispute. Number 1. No, the plaintiffs are the branch of Bajegoda. All of them represent the branch of Bajegoda. So according to them, they have become the property under partition of the year. What is the averment in the plaint?
Sons.
48 years ago, when was the suit filed? 97. So round about in the year 39.
The only one there is no document for that. There is no document for that. Yes, but there is no document. There are certain things but the Koredola was my uncle, brother of subsequently after getting
What was their difference
their difference is self-acquired property
of Oregon?
Self-acquired property.
What did they produce to show it is self-acquired property?
Oh, our standing.
If you say that the partition took place in the year 1939, 1940, and if the sale deed is of a subsequent period, then obviously they purchased it after the partition. What is your right over that property then when you yourself set up the plea of partition?
When we see the reasoning for that.
The reasoning and either first, how can you, what is the rate of the sale deed exhibit P3 and P11? There are two sale deeds that they produce. 1427. And that is 11. Let us see the written statement. Read the written statement. I have the version. I'll go by the version. Amended. Yes.
The relationship is repeated before. It also proved that certain brands need to follow the committee to the case. It is untaken. Become of their own diversity. Again, there are no. There was clear separation following. And property required. The property required to follow the constitution and not in the current money. There are property required individually. And property required to they are not the current money. First thing, we use also living they are having issues. Last group so also the had another so Vairama had a son Siddheva. The two daughters woman. The two daughters it is called as regular. Number 4 belongs to Christopher. This purchase is it has included the source of the
Plain para 4 was good. Plain para 4. Father of the first plaintiff.
The first plaintiff grandfather second of Rupert, reasons. Whatever, they also property taken and the set property were right. Doing the sons of other people in the same and
Who's plaintiff number 4 and 5? Both of them are daughters of Vajjagada. ಎಲ್ಲರೂ ಹೆಣ್ಮಕ್ಳು ನೀವು 3 ಜನ ಹೆಣ್ಮಕ್ಳು. So how do you think you have established that there was a partition and each schedule was granted to you according to you? Cannot. Reasoning, you know? No, what is the reasoning? ಏನಿಲ್ಲ ಅಲ್ವಾ? Anything to show, nothing to show that there was a partition. On Siddegowda, the admitted case of the parties is as follows. Siddegowda, on Siddegowda had 3 sons, Boregowda, Kuntumadaya, and Bajegowda. Apart from a daughter, Cheluvamma. The son, daughter, the son, daughters, and a son-in-law of Bajegowda are the plaintiffs who instituted the suit seeking for a declaration that they were the owners of e-schedule property. In this suit, they arrayed the branch of Boregoda as they arrayed the son of Boregoda as D1 and their uncle Kuntmadaya as D2. D2 and D3 are the sons of Kuntmadaya. Cheluamma, the daughter of Siddhegoda and the aunt of the plaintiffs, had died unmarried. The branch of Bajegoda basically contended that the sons of the three sons, that there was a partition, contended that Kuntmadaya, the second son of Siddhegoda, had separated himself from the joint family and he had been allotted e-schedule properties as his share under an oral partition, which was effected about 70 years ago. Actually, that is in 1927. approximately. It was their case that Bajegoda and Boregoda, the first and second son of Siddhegoda, continued to be in joint possession of the remaining properties. And they had acquired some more properties in the name of Boregoda. It was stated that Boregoda and Bajegoda entered into an oral partition about 48 years ago. It's 1950 alva, about 1949 is that, approximately 1949, in which the e-schedule properties had been allotted to the share of Boregoda. And on the death of Boregoda, about 45 years ago, they had succeeded to the suit property, to e-schedule property, as by virtue of being class 1 heirs. It was stated that his son-in-law, that is the third plaintiff, M. Ramchandra Gowda, was looking after the family affairs, and thereafter there was a strained relationship between Bajegoda's branch and Boregoda's branch. And therefore, they were constrained to seek for a declaration that they were the owners in respect of e-schedule property. The branch of Bajegoda contested the suit by filing a written statement. They admitted the relationship of the parties, but denied the contention that Bajegoda and Boregoda constituted a joint family. They stated there was a clear separation of all the members and the properties acquired subsequently, where the self-acquired properties of the persons who had purchased it. It was therefore contended that the properties purchased by Bajegoda were his properties and no right could be claimed over the said lands. He stated that Boregoda had acquired serial number 183, 185 and other serial numbers, and they were there and they were all his self-acquisitions. The assertion that in a partition, the e-scheduled properties had fallen to the branch of Bajegoda and been allotted to Bajegoda were false. It was also stated that all the class 1 heirs of Bajegoda had not been implemented. Therefore, the suit was not maintainable. The trial court framed 6 issues. D2 and Nakli written statement. The branch of Kuntumadaya were served and remained unrepresented and consequently placed ex parte. In support of their case, the first plaintiff Siddhagowda was examined as PW1 and 3 other witnesses were also examined. In all, 12 documents were admitted in evidence and marked as exhibits. On behalf of the defendants, the son of Madegoda, that is Pudmadegoda, D1B, was examined and another witness was examined, and on their behalf 5 documents were admitted into evidence and marked as exhibits. The trial court, on consideration of the pleas and the evidence adduced, came to the conclusion that Bajegoda's branch had failed to prove that they were the exclusive owners in possession of the issued properties. It held that the branch of Boregoda had proved that the issued properties were the self-acquired properties of Boregoda, and consequently, the branch of Bajegoda had no right over the same. The trial court accordingly proceeded to dismiss the suit. In order to come to this conclusion, the trial court has held that the branch of Bajegoda, though pleaded that there was an oral partition and the issued properties had been allotted to them 48 years ago, they had failed to establish this oral partition. The trial court has also held that the properties in respect of which a claim had been made indicated that they were all in the possession of the branch of Boregoda, and all the revenue entries also stood in the name of Boregoda. It was therefore not possible to accept the plea of the branch of Bajegoda. Learned counsel for the appellant contended that the judgment of the trial court could not be accepted since there was clear evidence to show that the suit properties, that the suit initiative properties had been allotted to Bajegoda. He submitted that there were also admissions to this effect. Therefore, the judgment of the trial court was incorrect. In view of this argument, in view of the argument advanced, the point that would arise the consideration is as to whether the branch of Bajegoda had established that there was an oral partition entered into 48 years prior to the filing of the suit, in which issued properties had been allotted to Bajegoda. As stated above, the specific case of the Bajegoda's branch is that the second son of Siddegoda got himself separated for 70 years. So 70 years prior to the filing of the suit. And thereafter, Boregoda and Bajegoda continued to be joint until they partitioned the properties in an oral partition entered into about 48 years prior to the institution of the suit. As the suit was of the year 1997, it is obvious that according to the plea of Bajegoda's branch, the oral partition had been effected in the year 1949. In the light of this plea, it was incumbent on them to establish that there was a partition in the year 1949, and they had been in possession of the properties allotted to them ever since. The branch of Bajegoda have, however, not produced any evidence, either oral or documentary, indicating that there was an oral partition in which the issued properties were allotted in favor of Bajegoda. Apart from producing a notebook which contained certain writings stating that land revenue had been paid, there is absolutely no documentary evidence to establish the actual division and the exclusive enjoyment of Bajegoda over the issued properties. It is to be stated here that the partition period was of the year 1949, and unless this partition was reflected in revenue records, the theory set up by the plaintiffs that there was a partition cannot be accepted. The trial court has taken into consideration the revenue records produced by the defendants, which indicated that the suit properties were standing in the name of Boregoda's son Madegoda. And this by itself indicated that the theory of oral partition could not be accepted. The trial court has reasoned that had there been a partition, the question of the name of Boregoda's son being entered in the revenue records would not have arisen at all. In my view, since there is absolutely no evidence, either oral or documentary, to indicate that there was a partition effected in the year 1947, the trial court was justified in dismissing the appeal. I find no reason to entertain this appeal, and the appeal is accordingly.
Validity.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಎರಡರಲ್ಲೂ ರೆಸ್ಪಾಂಡೆಂಟಾ? ಎರಡರಲ್ಲೂ ಏನ್ ಸೂಟ್ ಏನು? Suit is decreed. ನೀವು ಎಷ್ಟನೇ ಪ್ಲಾಂಟಿಫ್ ನೀವು? ಗೋಪಾಲ್. ಏನ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಏನು? ಇಲ್ಲ, ತುಂಬಾ ಹಳೆ ಮ್ಯಾಟ್ರ್, ನಾನು ಟೈಮ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಇವ್ರು ಬಂದಿದ್ರ ವಿನೋದ್ ರೆಡ್ಡಿ? ಬರ್ತಾರೆ. ಒಂದು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ, ಅವ್ರು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ DNP ಮಾಡ್ತೀನಿ. ಓದ್ಕೊಳ್ಳಿ ಈಗ, ಓದ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ಇಲ್ಲ, ಅವ್ರು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ. ಅಷ್ಟ್ರಲ್ಲಿ ನೀವು ಓದ್ಕೊಳ್ಳಿ. Super. Suit is dismissed. What is the property? Shop premises.
That was a condition. And the shop is situated at in 1984. Respondent to the procedure. When the official the tenant I had to, because they demolished, so I did not apply for that. When the demolition, the entire condition of the along with me, there are some other tenants also. Therefore, that demolition process depends on 25 legally. Therefore, when this was the condition, our landlord came and sat and discussed with me and all other tenants, saying that this is not possible for you to continue the business. Therefore, we shall have meeting, we shall have some agreement. Accordingly, you vacant and hand over the vacant position. Thank you. Question number 7. Demolition of between 2028. The meeting was held on 30th by night. But agreement justice says between 10 feet after
Agreement. Oral agreement is not in dispute. She admits in the written statement that there is
just set up some extra aspect saying that no, there was a memorandum not in the form of agreement in the agreement. In that case, there was a memorandum of understanding In fact, I have only to pay the extra payment of correction of this and 2 lakh rupees. But the purchase of according to them.
Who's in possession? She has rented it to somebody.
Somebody. But this construction is not 11 months from that day. And immediately after this agreement, I handed over the position. That was demolished. And immediately within 10 or 11 months, this new construction was. So immediately on completing the construction, question. Look, this was the agreement. Then they started. Well, within 2 days, I find this.
No, but I don't understand. Normally, whenever the property is to be given back to the tenant after reconstruction, would they normally accept for the same rent? Especially in ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಯೋಚನೆ ಮಾಡಿ ಎ ಎಸ್ ಆಚಾರ್ ಸ್ಟ್ರೀಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಗೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರೆ ಕಟ್ಬಿಟ್ಟು ಹಳೆ ಬಾಡಿಗೆನೆ ಕೊಡ್ತಾರ. ಅದು ಏನ್ ಬಿಸ್ನೆಸ್ ಮಾಡೋದು ನೀವು? ಏನ್ ಬಿಸ್ನೆಸ್ ಮಾಡೋದು? ನೀವು ಅಲ್ಲಿರೋ ಡಿಮ್ಯಾಂಡ್ಗೆ ನೀವು ಓವರಲ್ ಆಗಿ ಒಪ್ಕೊಂಡು ಆಚೆ ಬಂದ್ಬಿಡ್ತೀರಾ 1000 ರೂಪಾಯಿಗೆ. ಸ್ವಲ್ಪ ಬಿಲೀವಬಲ್.
ಈಗ ಆ ತರ ಅಂತ ಹೇಳಿದ್ರೆ ಅವಾಗಲೇ ಸಾಲ್ಬಹುದು. In fact, one of the cases that has been treated that is not even denied by the other side.
Where did you set up in the plaint regarding this oral agreement?
That is in it is in para number 3. In the middle of the para. Because of the condition, the plaintiff will represent this is the money used. Coming to the reconstruction.
ಅಲ್ಲ, ನೀವು ಇದರಲ್ಲಿ ಅದೇ ರೇಟ್ಗೆ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರ ಪೇಂಟ್ ಅಲ್ಲಿ? Plaintiff shall vacate and deliver the remaining unacquired portion of the premises in occupation of the plaintiff for the purpose of demolition, reconstruction, to put the plaintiff back into the scheduled premises only at the same rate ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರ?
ಇಷ್ಟೇ ಆಗಿದ್ದು ಬೇರೆ ಎಂದೇನು ಆಗಿಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ಇನ್ನು ಆ ತರ ಇದ್ದೀರಾ
What was this earlier suit? OS 3187 per 94?
But everyone is making about fight. Before this, before when this conflict started between me and this one, I wanted to stop. I said, no, that is not
What is the suit for?
you should not in violation of this.
In that suit, you yourself produce this memorandum of agreement.
But they said that they are producing memorandum. Says, I am not saying.
Why did you produce a memorandum then? Where is the plaint in that OS 3187 per 94? Is your plate, you should. Ideal, exhibit D1. Yes.
They rely upon exhibit D2. Exhibit D2, they are not good. What they rely upon exhibit D2.
What is G2? The court has recorded a finding, both while vacating the interim order and also in the appeal, about this agreement. And you also set up an agreement to let out shop even after demolition. This is your plaint. This is your document. You suppress this fact when you file the plaint. Why should we exercise a equitable jurisdiction in your favor? Where have you said that there was a memorandum agreement entered into between you and your landlady, where she would reconstruct and hand over possession to you?
You see, based on what evidence is there. They say the brother-in-law of the plaintiff has signed the paper. It is not the plaintiff, the brother-in-law of the plaintiff has signed the paper. Whereas the plaintiff had agreed to pay the amount of this and the brother-in-law of the brother-in-law of the plaintiff disclosed the time stating that he has signed the said paper on the plaintiff. He has not produced the said agreement entered into between the parties on the paper. Because the agreement is one smash. So it is not in my motion, not the motion, my motion not independent.
So if that MOU is not there, your right of re-entry is not there. For them, for you to contend that there is an admission of an agreement.
No, I'm not admitting this.
You are saying there's an oral agreement.
Yes.
They are saying there's an MOU entered into, which was signed by your brother-in-law. So if you ignore their case, your only cases of an oral agreement. How did you establish the oral agreement?
Whatever the previous certain there is no denial.
The denial is there in the sense they categorically state that there was an MOU that was entered into, in which your brother-in-law was a party. The entire property had been demolished. Therefore, the injunction was also vacated. In the appeal that you had filed, did you take up the plea that there was no such MOU?
Yes, sir.
Where?
That is the case. That is the case.
Your complaint before this court was that they had colluded with the corporation authorities and there was severe damage caused to you. Liberty was reserved to you to file a suit for damages.
That was right. That was right.
Then where was this plea of this oral agreement taken up then? You should have said when. So after that filing of the suit, present suit is filed, setting up the plea of an oral agreement. See, if there was an oral agreement, you could not have filed the suit. Because according to you, the oral agreement was that, all right, please take back this premises. After you reconstruct, you give it back to me. On the other hand, you said, no, don't demolish. I intend to continue the business. Then where is this oral agreement? Where? You should have said so. Did you say that there was an oral agreement and going back on the oral agreement and therefore I am constrained to file the suit? That is not your case. You don't say anything about this oral agreement. Then I can't accept that oral agreement theory after you suffer an order of by this court. This suit was filed when?
1995.
Date. This was for, this agreement of yours was when? When?
1994.
Oral agreement was 35/1994. Why did you not mention in this suit that there was an oral agreement? No, in the earlier suit.
Because the scope of the suit was not right.
What is the prayer in the suit? Please see the prayer in the suit. Declaring the continuation of business in the portion of the premises under occupation shall by making necessary alteration at the cost of plaintiff if D1 failed to do is legal and valid. So you said you are entitled to continue in possession by getting that property repaired at your own cost. So this entire theory of yours that you surrendered possession for reconstruction is a false contention. Hello, Ramesh. I'm not going by them. I'm going by your conduct. You say 30th of May 1994, there was an oral agreement whereby you agreed to surrender possession. They would construct and give it back to you at the same rate of rent. You file a suit in the year 1995 without whispering anything about this oral agreement and saying that you're entitled to continue in occupation and by permitting you to repair it at your own cost. If you have not set up the plea of surrendering of possession, this entire story comes to the ground. No, I'm not prepared to accept that your conduct is good. You cannot say contrary things in two suits to the court. All right. In a specific performance suit also, it's of no consequence.
Apart from this, there is a benefit of the office of the director. Step of human legal responsible possession.
You don't even, we will ignore the MOU. MOU you don't accept. We will ignore the MOU. How can you succeed on the basis of an oral agreement that you set up, which you did not mention in the year 1995 when you approached the court? It is not necessary for you to state there. So you can lie to the court then, saying that you're in occupation and now contend. Then no, that you had surrendered possession on 30th of May 1994. Alva, isn't it the conclusion? One way or any other way, no matter which way you look at it. Once you set up the plea of surrender, how could you have filed that suit? And having filed that suit in that particular manner, how can you now be permitted to contend that no, I had surrendered possession under an oral agreement? Either this is true or that is true. Either way, there is no oral agreement. How better? Even you have come to the court seeking for specific performance. Why should you talk about what they can do or cannot do? Their case was simple. All of you surrendered possession by entering into an MOU. You suppressed the MOU. If you had sought to enforce that MOU, that is one thing. You're denying the MOU. So whatever admission they had given in your favor of putting you back to the property is lost. Your only ground is oral. Oral will fail because of the plaint that you have filed. Tell me. Okay, I'll consider. But you are not even pressing that MOU, and I am ignoring that MOU completely. So we will ignore the MOU. This judgment will have no application. This judgment will have application only if you admit the MOU, and then the MOU atra madakagala, blackmail madakagala anta correct me hedu. ನೀವು MOU ನ ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಿಲ್ವಲ್ಲ. So that has no application at all. ಅದಕ್ಕೆ ಬಿಟ್ಬಿಡಿ. So your only argument is oral agreement. Oral agreement improvement ಇದೆ ಹೇಳಿ. Please tell me where they have agreed as per your condition, the oral agreement, just to give back the property, and they'll even according to you, it was not giving back the property to you at the same rate, and they would retain the advance of 50,000. That is not your case. Then let us read the written statement.
Around
17. Paravise read. I have the original. So paragraph 17B na. 17 regarding para 2 na regarding para 3 na?
So the para two, para three,
No, they're giving reply to each paragraph. Which paragraph, which Verma do you want me to give?
sufficient is whatever the things that we did, there is no
No, there's a reply in para 17 regarding para 3 and the please. No, no. Without praise to the above foregoing, this defendant seeks leave to traverse the averments made in the plaint. Now regarding para 3, please read. It is true that
It is true that the Raj consider that the it is also true that they have other law. In the secretary cost, it is
they don't admit the oral agreement. They set up the memorandum of agreement. So where is the admission that about the oral agreement?
Because already provide specific lesson, there was specific design.
Yes.
There is no proceeding of that petition.
No specific denial. So that is your entire case now. And this amounts to an admission.
The issues spread. This is the one that
Yes.
you are trying to do that. The trying to tell of the reconciliation of the state of the state, we have to take it to the defendant and demolish the state picture of the federal funding. So trying to do that. We can agree to that. So because there's not delay.
No, no. Both these questions will have to be answered in favor of the plaintiff because it is a fact. It is not in dispute that the possession was delivered.
And again,
Let us see. Let us read issue number 2.
was mentioned to that.
Where is the answer to issue number 2? Paragraph. Paragraph. Yes. You had filed 3 suits.
Very on top of land because the land is located.
Yeah, the assured number, no? 2075 bar 1995. You produce agidya? Exhibit T2. This was filed on 24/3/95.
It was back in the year 1995. And during that time,
Did you state in this plaint about this oral agreement? No, there's nothing in this. You don't even state that you had surrendered possession. You state that illegal, though the notice was being served on the defendant on 4195, plaintiff has not proceeded nor has taken any action to return the amount payable to the plaintiff in the eye of law. Instead, the defendant with the malafide intention to escape from payment of the advance amount lying with her has resorted to an illegal act of removing the movables belonging to her outside the jurisdiction of the bank of the High Court with an intention of delaying or defrauding. So you wanted refund of this amount. If you contend that you had to get the amount refunded, how can you say that you will be entitled to continue? Where is this plea of this oral agreement? See, this was filed on 24/3/1995. There is nothing, nothing about oral agreement of sale. Oral agreement of putting you back in possession. Then the next suit is, this was the earlier suit, isn't it? 3187/94. Which you filed on 8/6/1994. Which is the third suit? Was 2079/95, was 3187/94. ಇನ್ನೊಂದು ಯಾವುದು? ಮೂರು ದಾವೆ ಅಂತ ಅಂತಾರೆ ಅವರು. So the direction to pay back the advance amount also. ಇದ್ರ ಮೇಲೆ appeal ಹಾಕ್ಲಿಲ್ವಾ ಅವರು? So that 50,000 is given back to you. ಇದ್ರಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ನೀವು ಓರಲ್ ಅಗ್ರಿಮೆಂಟ್ ನಾನು ವಾಪಸ್ ಕೊಡ್ಬೇಕು ₹1,000 ಬಡಿಗೆ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ನನ್ನ ಹತ್ರ ಇದೆ, ಓದ್ದೆ ಇಲ್ಲ. I don't know, but I have a copy of the plaint. 2075 JT by. Nothing. There is not even an indirect whisper about surrender of possession or about an oral agreement in writing. Thereafter, you file you file a suit to continue in occupation by getting the shop repaired at your own cost. Then you file a suit for refund of the advance amount. In neither of the suits, you talk about oral agreement. And this is the third suit that you have filed, saying certain. ಮೋಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಫಸ್ಟ್ ಅಲ್ಲೇ ಇರಬೇಕು. ನೀವು ರಿಪೇರಿ ಮಾಡಿಸಿ ನಾನೇ ರಿಪೇರಿ ಮಾಡ್ಕೊಳ್ತೀನಿ, ಅಡ್ವಾನ್ಸ್ ವಾಪಸ್ ಕೊಡಿ. ಎಲ್ಲ ಆದ್ಮೇಲೆ ಈಗ ಇಲ್ಲ ಇಲ್ಲ ನನ್ನ ಓರಲ್ ಅಗ್ರಿಮೆಂಟ್ ಇತ್ತು, ನನಗೆ ಅದೇ 1000 ರೂಪಾಯಿ ಬಾಡಿಗೆಗೆ ವಾಪಸ್ ಅಲ್ಲಿ ಒಳಕ್ಕೆ ಹಾಕಿ.
Paragraph print ತೆಗಿ.
Continue at 2:30.
My lords, appear for the respondents will appear physically before my lords.
I did not prevent you.
My lords, I was under the impression first half of the morning my associate said 2:30 matters will not be taken today. My lords,
No.
that
I
was
said-
what was.
No, come at 2:30.
Please, my lords. Please, my lords. Highly obliged, my lords.
ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ ಅಂದೆ ನೀವು, ಹಾಕಿ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಆರ್ಗ್ಯುಮೆಂಟ್ ತಿರ್ಗಾ ಅವಕಾಶ 10 minutes ಏನಿಲ್ಲ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ ಕೊಡಿ. ನೀವು ಏನ್ ಕೊಟ್ರಿ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ, ಅಲ್ಲಿ ಕನ್ಸಿಡರ್. ಎಸ್, ಯಾರಿಗೆ? Seventh, 8.
Court officer. Court officer, causes to serial number 2 ಏನಾಗಿದೆ ಹೇಳ್ಬೋದಾ ಸ್ಟೇಟಸ್?
Total 18. ಹೋತಲ್ರಿ ಇದು ಹೋತ್ರಿ ಇದು ಮತ್ತೆ ಕನೆಕ್ಟಿಂಗ್ ಅಂತ ಬರೋದ ಓಕೆ ಇದೇನ್ ಕೊಡ್ಲಿರಿ HP ಆಡಿಯೋ echoing ಆಗೋಲ್ಲ ಮೊಬೈಲ್
Partition between will be relevant for this suit. It is tomorrow, day after tomorrow. Well, chamber. And you want Next Tuesday. Next Tuesday. Give me 10 minutes. I'll finish the Dharwad list and then. No, they also challenge this concept of rowdy shooting after Putswami's judgment. Whether this concept of rowdy shooting is an infringement of the right to privacy. They have raised. They made a prayer. That is why it was heard for some time. And then
Actually, prayer was made in 104332.
104332. That was the main matter that was argued. 4332. The way for amendment. No, ಮಾಡಿದ್ದಾರೆ. On 30/11/2022, I allowed the application. And you are asked to file the additional objections also. One 104,332. Set aside the rule of 1059 of Police Manual. Another arbitrary decision. Set aside the arbitrary decision.
My prayer is wash the notice sheet.
ಅದಾದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಆನ್ 30th of May. Because I also entertained a doubt as to whether you could maintain something called as a rowdy sheet, which may infringe his right to privacy. Is not, you are not able to trace it to the police act. This is 21. Mr. Nadaf. Please serve an additional copy on the SPP.
Yes, sir, I will, sir. I have already served 2 copies to the Dharwad, sir.
It was served in date 10th.
Much obliged.
Whenever you want. Written Vidya? ಇನ್ನೊಂದು ಪಾರ್ಟ್ ಇದೆ ಮುಗಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ತಗೋ.
Representing LRs of respondents. Dharwad bench.
Dharwad bench, I'll pass it over. I have another matter. Please don't come back.
Please, minutes.
What is the suit for? declared no, suit is declared that suit B schedule property is not the part and parcel of property shown in OS 691, 6103 and 4689. And the decrees are not binding on the plaintiff. The defendant number 4 and 5 are directed to deliver vacant position of the suit schedule C properties. Who's in appeal? Challenging? Against which portion of the decree is he challenged? Partly decreed in the Bardilvala. The prayer according to page 16 is same against defendants for declaration that the suit B property is not a part and parcel of suit property described in zone. Decree passed in the sections are not binding for mandatory injunction to put and deliver vacant position. The entire thing is decreed. Plaintiff is Syed Yusuf Ali. Defendant number 1 is in appeal. What is the compromise? Both the plaintiff and first defendant. All the defendants. All the defendants. Day 1/23 is filed to implead Jamil Ahmad and Amjad Khan, who have purchased the suit property from both the appellants and the respondents in the pendency of this appeal. Since the proposed respondents would have a direct interest in suit property, they are impleaded as respondents 10 and 11. First it will be amended. You can simply withdraw the suit. I'll record this. How can I declare them as the owners? In a suit filed by the plaintiff, it's been decreed. Now he wants a decree to grant instead of response 10-11 that they are the owners. I will record that and say that the appeal becomes unnecessary. That should serve a purpose. A compromise petition is filed. All of them are present. This appeal has been filed by the first defendant, challenging the decree of the trial court, by which the trial court has declared that suit schedule B property is not the part and parcel of the property shown in OS 691/1980, 6103/94 and 4689/86. The trial court has also held that the said decrees would not be binding on the plaintiffs and that fourth and fifth defendants, that is, who are the respondents here? Fourth and fifth. Papamma and Venkatesh. Yes, respondent 8 and 9 would have to hand over possession of the suit schedule C properties within 1 month from the date of the decree. Trial court has also restrained defendants 1 to 5 from interfering with the possession of B schedule property by the first respondent plaintiff. The compromise petition is filed stating that the plaintiff, ಒಬ್ಬರೇ plaintiff ಅಲ್ವಾ? ಎಲ್ಲರೂ ಮಾಡಿದಾರ? Where is the sale deed? We produce a sale deed. Grant counsel for the respondent submits. When comes to Naveed Ahmed submits that where's the other sale deed? Sale deed. Give it back. Give a copy of this. Syed Yusuf illa idralle. This is son of late Syed Hussain. Then who has executed this sale deed? This is Syed Shabuddin. The plaintiff frankly. Plaintiff are different. No. Abdul Jabbar is a defendant. Plaintiff is Syed Yusuf Basha Minabi. The parties here have convened. Who are the parties? Submits. The compromise petition states that the parties to the appeal entered into an agreement of sale on 7/2/2020 with respondents 10 and 11, and they have in turn paid a sum of rupees 45 lakhs as detailed in the compromise petition. And a sale deed is also executed in favor of respondents 10 and 11 on 14/10/2022. It is stated that in view of the above, the appellant does not have any right, title or interest in the suit property, and that they will be withdrawing all the claims and cases in respect of the suit property. For the sake of clarity, the terms of the compromise read as under. There are three in the, there are eight in the prayer. There are eight reversed. The compromise petition is signed by the appellant, the GP holders of respondent 1A, B, and C, and a GP holder of respondents 2A, 2B, my GP holder of respondent number 3A. Illano number signed by the GP holders of R1A, R1B, R1C, 2A, 2B, 3A, 4, 5A, 5B, 5C, 6A. The seventh respondent has also signed the compromise petition on his own behalf. Respondent number 8A and 9A have also affixed their signatures. R9A ಯಾರು ಗಂಗಮ್ಮ? ಯಾರು ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ? You will identify. Naveed Ahmed, counsel for respondent number 1A to C, and the other respondents identifies R9A. R8. R8A and B. Oh. She is the same. Stated that R8 is no more, and our LR is already in record as R9A. Said statement is taken on beginning the conclusion. The 11th respondent has also affixed his signature. In view of the fact that the parties to the appeal have conveyed the properties in favor of respondents 10 and 11. Now it is obvious that the appeal itself would not survive, and the decree declaring that Syed Yusuf and others were the owners will now stand superseded by the sale executed by them in favor of respondents 10 and 11. Consequently, taking this compromise petition on record, the appeal is disposed of. What is a decree? The manner which you have compromise decree is declaring respondent D10 and 11 as the owners. Therefore, I have said that, saying that they have lost title and they have become owners. They can't draw a decree in an appeal filed by D1 in favor of parties are present. They acknowledge the access. Give a copy of that.
seeking refusal. But I'm not ready. I will see.
Please, sir. Yes.
My time is selected the different ways of the partner and partner. My intention is that I is when without my life in getting the part in the present. Therefore, because human friend. Decision making. So that's what the intention is not to be right, but in the present. So, let's say that's something belongs. And now you see that do not include person the offenses are the level. So I want this so it gets all there is even that. When I was being related to the soul, then the management their undertaking will be some state, right? We and because I think that make the person, the party who is a nicer person of becomes there is one kind of necessary problem.
You will respondents are that don't for yourself.
And
You simply have to establish that there is an oral agreement in writing. And according to there is an admission. There is no specific denial, therefore there is an admission. Forget about their defense. Your simple cases is an oral agreement in writing. And because there is no specific denial, it amounts to admission. That is your fundamental argument.
on the other side is trying to become executive because evidence that I is there. No, there is not and no has documented. My solution is
Correct. Result. Meenakshi Metal Mart, a proprietary concern represented by Jyoti Bai and Jyoti Bai herself, instituted the suit against Sheila Srinivas Murthy, seeking for direction to be issued to Sheila Srinivas Murthy to deliver possession of shop premises bearing number 16 from a new number G17, which was situated at the ground floor in Arcot Srinivasachar Street, Bangalore, measuring 11 feet 9 inches by 8 feet 9 inches on the northern side and 24 feet on the southern side. A decree of injunction was also sought for to restrain Srimati Sheila Srinivas Murthy from leasing out or alienating the property in favor of anybody else. It was a case of Jyoti Bai that She was a tenant in respect of premises, respect of the above mentioned premises, measuring 11 feet 9 inches on the eastern side, 8 feet 9 inches on the western side, 34 feet on the northern side, northern and southern side, on a monthly rent rupees 1,000 under Sheila Srinivas Murthy. She stated that the corporation acquired land to the extent of 10 feet adjoining the ACHR street, and it also demolished the buildings on either side of ACHR street, including the premises which was in her occupation, to an extent of 10 feet on 28th of May 1994. She stated that on the account of the said demolition, the rafters and beams supporting the roof came down, and the remaining portion of the building in her occupation was in a precarious condition and was likely to come down any moment. She stated that at this stage, she and Sheila Srinivas Murthy, through her husband and GPA holder, met and discussed and ultimately entered into an oral agreement on 30th of May 1994. So, under the terms of this oral agreement, she agreed to vacate and deliver the remaining portion of the property which had not been acquired by the corporation and which was in her occupation for the purposes of demolition and reconstruction, with the condition that she was to be put back into possession of the suit property. She stated that she accordingly delivered vacant possession to Sheila Srinivas Murthy on 31st of May 1994. She went on to state that Sheila Srinivas Murthy had reconstructed the shop, but she did not abide by the terms of the oral agreement, despite several requests made by her to give effect to the oral agreement dated 30th of May 1994. She stated that Sheila Srinivas Murthy, taking undue advantage of the situation, had become greedy and started demanding exorbitant rate of rents in advance, which was impermissible in the eye of law. She stated that when she refused to concede to the demand, she was given to understand that she would not be put into possession of the premises and she would hand over the same to other third parties. Jethubai contended that she had a right to enforce the agreement dated 30th of May 1994, and hence she was constrained to approach the court seeking for specific performance of the oral agreement. She also sought for declaration that she was a tenant in respect of this premises. Sheila Srinivas Murthy entered appearance and contested the written statement by filing the written statement. She admitted that Jethubai was a tenant. She stated that she was the owner of the premises bearing number 16 to 25, and this premises and this property contained a ground and a first floor. In the first floor, in the ground floor, there were 5 shops, the occupation of 5 tenants, while the entire first floor was inner occupation. She admitted that in one of the shops, Jetubai was in possession. She claimed Jetubai was in the occupation of one of the shops. She admitted that the corporation acquired an extent of 10 feet of her property, which was abutting Arcot Srinivasachar Street. And on 28/5/94, they commenced demolition of the property. In this demolition drive, the property to the extent of 10 feet was also demolished. And when the demolition work commenced, all the tenants vacated the portions in their occupation. She stated that as a result of the demolition, the rafters and beams supporting the roof came down, and the remaining portion of the building was in a precarious condition and was likely to collapse. It was therefore impossible for the tenants to carry on the business. She stated that in that existing situation, all the 5 tenants and her husband held a meeting at number 47 Mamulpet, Bangalore. And after on 30th of May 1994, she stated that in this meeting, Jetubai was represented by her brother-in-law, Dilip Kumar. She stated that it had been agreed at the meeting that the entire building would be demolished fully and 6 shops were to be reconstructed in the ground floor. And each of the 5 tenants would be provided with 1 shop, and the remaining 6 shops would be occupied by her. She stated that it had also been agreed that each of the tenants would pay an advance of rupees 3 lakhs and a rent of rupees 3,000 per month. And accordingly, a short memorandum of the terms agreed upon was recorded. It was signed by all the parties. She stated that suppressing all these facts, the present suit had been filed on the basis of an oral agreement. She stated that she was never present at the meeting held on 30th of May 1994. And the allegation of an oral agreement was not forthcoming in the earlier proceedings. And she had also suppressed the execution of the memorandum, pursuant to which the tenants had vacated and handed over vacant possession. She also stated that the memorandum which was entered into was accepted by Jetubai in the earlier suit that she had filed against her in OS 3187/1994. And in fact, this document had been produced along with the list of documents accompanying the plaint. She stated that subsequently, the memorandum had been changed by interpolation and one more sentence had been added, which could be gathered from a reading of the said memorandum. She stated that this was being done by taking advantage of the fact that the memorandum was written by one M.R. Mahesh, who was one of the tenants and was allowed to remain in possession. She stated that on 31/5/1994, the entire building was completely demolished and she was about to take up the construction work, and at that juncture, Jetubai had issued OS 3187/94, contending that she be permitted to continue carrying on the business the part of the demolished shop. She stated that she also obtained an ex parte interim order. And in the said suit, there was no whisper of any oral agreement which had been set up in the present suit. She stated that the ex parte interim order granted was vacated. She also stated an offer was made that a new shop would be constructed and delivered to her in terms of the memorandum of agreement, but the said offer was not accepted. She also stated that the appeal filed against the order vacating the ex parte order of temporary injunction was confirmed in MFA 145/95. She submitted that since this oral agreement which had been set up in the present suit was not even referred to in the earlier proceedings, the entire claim by her could not be entertained. What is this OS 5899/94? That is still pending. Paragraph 12 of the written statement is said OS 5899/94. What happened to that suit? Do you have any idea? OS 5899/94. She also submitted, she also stated that she had filed a suit in OS 5899/94 challenging the construction. And in that suit also, the oral agreement had not been stated. It was also stated that she had filed yet another suit in OS 2075/1995 seeking for refund of ₹50,000, the advance amount. And in this suit, which had been filed on 24/3/1995 also, there was no mention about the oral agreement. She therefore contended that since this theory of an oral agreement had never been set up in the earlier proceedings, her claim could not be entertained. Was also stated that she was prepared to reconstruct and deliver the premises as per the terms of the memorandum, and that she had always been ready and willing to do so. But it was Jetubai who had refused to act in accordance with the terms of the memorandum. She also stated that she had leased the premises to one N.K. Narendra Kumar under an agreement of lease, and he was in possession as a tenant by paying a monthly rent of ₹3,000 and an advance of ₹3 lakhs. He therefore contended that since there was no oral agreement as contended, the suit to enforce such a non-existent oral agreement could not be entertained. The trial court framed 7 issues in support of her case. She examined one Kundan Lal. How is he related? Kundan Lal yara?
He's the husband.
Then she examined the husband and power of attorney holder Kundanla, and through him, 4 documents were admitted in evidence and marked as exhibits. On behalf of Sheila Srinivas Murthy, her husband N.S. Srinivas Murthy was examined, and through him, 7 documents were admitted in evidence and marked as exhibits. The trial court, on consideration of the pleadings and the evidence, came to the conclusion that Jetubai had proved that she had delivered vacant possession of the suit property in her occupation, and also the demolition that took place on 31/5/1994. The trial court also held that she had agreed to hand over the ground floor portion of the premises to Sheila Srinivas Murthy. The trial court, however, held that she had not established that Sheila Srinivas Murthy had failed to put her back in possession of the suit property, and that she was not entitled for possession of the suit property. The trial court accordingly dismissed the suit. The trial court, in its judgment, has noticed that the oral agreement of sale that had been put forth by her had not even been mentioned in the earlier proceedings. And in the light of the fact that a memorandum of agreement had been admitted by her in the earlier proceedings, the present suit filed seeking to enforce the oral agreement dated 31/5/1994 would not be accepted. Tenant counsel for Jetubai contended that there was no specific denial of the assertion of Jetubai that there was an oral agreement. He submitted that since there was no specific denial as contemplated in order 835 of the CPC, it would have to be taken as an admission on the part of Sheila Srinivas Murthy regarding the alleged oral agreement. He sought to contend that the memorandum of agreement relied upon by Sheila Srinivas Murthy had not at all been established, and therefore it will have to be presumed that there was an oral agreement and Jetubai was entitled to be put in possession pursuant to the oral agreement. Shri S.K. Vicharapati, Learned Senior Counsel, appearing on behalf of Sheila Srinivas Murthy, on the other hand, supported the judgment and decree and contended that there was no oral agreement at all. And the fact that Jetubai did not even make a mention either directly or indirectly in 3 earlier proceedings by itself proved that there was no such oral agreement. He also submitted that since Jetubai contended in OS 3187/94 that she was in possession and was entitled to continue in possession, and subsequently in OS 2075/95 sought for refund of the advance amount, it was obvious that her present plea that she surrendered possession under an oral agreement could never be accepted. After hearing both the learned counsel, the point that would arise for consideration is as to whether Jetubai had established that there was an oral agreement dated 31/5/1994 by which Sheila Srinivas Murthy had agreed to reconstruct 6 shops and put her in possession of one of those shops. Next. As already narrated above, the case put forth by Jethubai was that there was an oral agreement on 31/5/1994, which was entered into because of the act of demolition of the premises by the corporation on the 28th of May 1994. According to Jethubai, Sheila Srinivas Murthy had agreed to reconstruct 6 shops and put her in possession in respect of 1 shop. An argument is advanced that by virtue of the oral agreement, Sheila Srinivas Murthy was under an obligation to put Jethubai back into possession of 1 shop at the same rent of rupees 1,000. The plea in the plaint, however, is not to the effect that there was an oral agreement on 30th of May 1994, whereby she would vacate and deliver the remaining unacquired portion with the understanding that on reconstruction, she would be put back into the scheduled premises. The plaint government does not state that the agreement was that she would be put back into position on the same terms as existed as on the date of the demolition. Jethubai contended that by virtue of this oral agreement, she had surrendered possession. However, admittedly, in the suit OS 3187/94, which had been filed on 3/6/1994, that is 3 days after the oral agreement, she contended that she had continued in occupation notwithstanding the demolition, and that she was entitled to continue to do business in the remaining portion. Thus, and in the very first litigation, she did not admit that she had surrendered possession. If this factum of surrendering of possession is not admitted at the earliest point of time, the argument that there's an oral agreement whereby she surrendered possession can never be accepted. Subsequently, she filed yet another suit in OS 2075/95 on 24/3/1995. In this suit, she sought for refund of the advance amount of ₹50,000 that she had paid to Sheila Srinivas Murthy at the time she had been inducted into the property. Even in this suit, she did not contend that there was any oral agreement. It is to be noticed here that if the oral understanding was that she would be put back into position under the same terms that existed as on 30th of May 1994, the question of seeking for refund of the advance amount would never arise. This is yet another factor to indicate that there could not have been any oral agreement in writing. Next. Apart from these 2 suits, she had also filed a suit in OS 5999 5899 of 1994, seeking for an injunction to restrain Sheila Srinivas Murthy from proceeding with the further construction of the property. If, as a matter of fact, there was an oral understanding that Sheila Srinivas Murthy would construct and hand over possession of one shop, the question of there being an attempt to prevent the construction itself demolishes the case of Jetubai that there was an oral understanding. It is also to be stated here that the suit premises is situated in the heart of the city and the rentals there are abnormally high. And in such a situation, to expect a tenant to enter into an oral understanding whereby the landlord would agree to reconstruct and redeliver possession at the rent that existed at the time of induction of the tenant originally would be highly improbable. I am therefore of the view that Jetubai has miserably failed to prove that she had surrendered possession under an oral agreement under which there was an obligation on the part of Sheila Srinivas Murthy to reconstruct and redeliver possession. I am also of the view that the conduct of Jetubai indicates her entire actions were mala fide. The fact that she filed 3 suits in which there was not even a whisper about any oral agreement only indicates that the litigation has been initiated solely to harass and victimize Sheila Krishnamurthy. In my view, there are absolutely no grounds to entertain this appeal. The appeal is dismissed. However, I am also of the view that since a deliberate attempt was made to mislead the court and false statements were made that there was an oral agreement in writing, which Jetubai has miserably failed to prove, she would be liable to pay costs of rupees 25,000 to Sheila Srinivas Murthy within a period of 1 month from today. Appeal is accordingly dismissed.
Is a fact being clarified.
You made them undergo, made them defend 4 suits. I wanted to do 50,000 advance ವಾಪಸ್ ಕೊಡಬೇಕು ಅಂತ ಇದ್ದೆ. Then I thought maybe 50,000 is a bit too much. Came down 25,000. I think we should discourage such litigation. She is a business lady. She should know better than to come to the court and do all this. Attempt has been to somehow stick on to the property one way or the other. Then offer was made in the suit that even now, if you are ready to abide by 3,000, 3 lakhs, you is prepared to give you a shop. That offer is made in writing in the written statement. You chose not to grab that offer. You wanted the premise 1,000 rupees and 47,000. Your conduct is definitely not moral. For the first time, I saw that there was an acceptance in the written statement about such oral understanding with the tenant. And the landlord had the grace to say, I am prepared to abide by the terms of the lease. Take back at 3,000 rupees. You said no. I think she is entitled for costs.
Forward bench matter, serial number 2.
Presenting LRs of respondent number 2 members.
Genealogy ಇದೆ. Fourteen by 64. No, 25,367.
The registration of
14,564.
after adoption, like, this does not been acted on. Meanwhile, on 9/1965,
Yes.
this is partition of the Germana and first right.
Sharbarna
Germana sons, Naginappa, Anappa,
and Shiva Savitra. Yes.
Partition day.
Me too.
And thereafter,
He said Manappa's wife is a party to this. Manappa's wife is a party to this partition deed. I've written here that even Manappa's wife is a party to this partition. That is the but ಈ ಪಾರ್ಟಿ ಮನ್ನಪ್ಪನ ಹೆಂಡತಿ ಪಾರ್ಟಿ ಆಗಿದ್ಲ. Manappa was also a party to this. Manappa has also signed this partition. One ನಿಮಿಷ. Partition is between Naglingappa. ನಾರಾಯಣಪ್ಪನ ಇದ್ರಾ? ಇಲ್ಲ ನಾರಾಯಣಪ್ಪನ ಇದ್ರಾ? ನಾರಾಯಣಪ್ಪ.
Also party in this partition notes.
ವೀರಭದ್ರಪ್ಪ. ಸಾವಿತ್ರಮ್ಮ. Yes.
In the second partition, there is a partition. One of the Henry father of Precarity, what we understand number one. He was given 30 partition.
Yes.
It's a partition deed and that is the law. They are sold on 15,970.
Yes.
8 acres on 14/7/1976.
14?
7/1976. And 4 acres on 13/4/1977. And 8 acres on 13/5/1980. By registered partition, registered standing.
So all 30 acres sold.
But the 30 acres includes the share also. Whatever you say, get partition, 30 share. But there to that, since the year 1980, he filed a suit. The Precarity adopted son. He filed a suit telling that governments are there, but my mother, that is your adopted mother, he has a weak minded, and the partition which has been effected is unfair, And implication of the respondent, the sons of Ravana, is true that the partition deed has not been, the partition deed has not been acted. Proof where this partition deed is unfair and but there also my when the filed suit, the plain governments.
When was the suit filed?
Suit was filed, but
23/7/19.
1985.
What is the OS number? OS number.
284 of 1985.
85 bar? 284/95.
85.
95.
75 is the partition deed, registered partition. 85. When the partition deed was effected on 9%, and then my mother and she, therefore the earlier partition 9%. This is the prayer made by the respondent of 1 year, the adopted son does not pay. But he filed suit on 23/7/1980. But I got the 3.36. It has been traded. But 2/1964. He said that I was a minor of after 18 years, but that 2/1982 is the attendant majority. After attending majority, 3 years is added. 2/1985.
84.
85. 3 years, 82 years. 85. 2/1985. The suit actually have been filed on the 1985. Admittedly, the suit was filed on 23/7/1985. To the border limitation. And this is the one.
What was granted to her, to his mother?
30 acres.
To this Savitrama?
8 acres.
Vidya ಮಾರ್ಬಿಟ್ಟಿದಾರ?
ಎಲ್ಲ ಹಾಗೆ ಇದೆ. That has been acquired by the registration.
8 acres is still with Savitrama.
But he created the Gandhi influence and clarify of the income. There are 9 of the paint. Property mentioned in the schedule is absolute property because the paint is allowed to further, the bench is allowed to further and not ability. Release the company. Paint permits partition is unfair, inequitable, and otherwise executed. And we are being given to share the students and the hands. It's further given our right about the of so there is a reading because to undue influence unfair and also but only feeling is there. no issue has been raised. But though there is no issue, but the trial court of filing the suit, there is a directive for the when the tenant spoken to the details. In the meanwhile, nominations. The final place. The second, the adopted father. The genetic father not filed a written statement at all. But when the matter was for evidence, what is the respondent number one? Entered into the witness box and he suddenly he gives up. Because there has been any reason, no application, nothing. But the evidence they are saying
This indicates that he wants to protect his father, but he wants to go only against the
and the evidence is just evidence of what is
ideally, she does not dispute it really.
therefore, the trial court, the reasons
What did the trial court do? What did the trial court do? Like ಏನ್ ಮಾಡಿದ್ರು first degree ಮಾಡಿದ್ರ?
Degree has been passed. Dealing about the 64 acres and 30 acres. Leaving that remaining house find appeal not
What was reason given by the trial court? ಹೇಳಿ ಸಾಕು ನೀವು ಓದೋದ್ ಬೇಡ ಹೇಳಿ ಸಾಕು. ಬರೀ 8 ಎಕರೆ ಕೊಟ್ರಿ ಈ ಬ್ರಾಂಚ್ಗೆ.
No evidence. What is the ground here?
Mother was not examined. Mother was alive.
Mother was alive. In the meanwhile, she died of disease.
But he accepts the adoption. He admits the adoption.
Adoption, there is no dispute because it is registered by the court.
No, he admits the adoption.
Only question is whether this unfair will be fair. For argument's sake, if I taken the 34 acres, 30 acres, not for what we know is that the 34 acres has to be divided among the post on one branch. So,
According to the suit left to fail because he gave up Manappa. They should have been there. If there was an equal partition, then this entire branch should have been given 30 acres and 30 acres to his mother. 8 ಕೊಟ್ರು ಇನ್ನ 22 ಸೇರ್ಸ್ ಕೊಡ್ಬೇಕಿತ್ತು ಅಲ್ವಾ ನಿಮ್ ಪ್ರಕಾರ? ನಾಗ್ಲಿಂಗಪ್ಪನ 9 ಎಕರೆ 25 ಎಕರೆ 29. So he has sold the entire land granted. He has not retained any land for himself.
It also has a question of law. Question of whether the Dasataya was given away we realized for 9%. This is this is below.
ಏನು ಅಂದ್ರೆ ಬಾಡಿಗೆ ಒಂದು ಸಂಸ್ಕೃತ ಮೆಸರಿಗೆ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ.
ಅಲ್ವಾ?
Judgment which I agreed upon is murder. That means my friend also is there. For 2020, 45 cases we have 980. And 600 reported in the judgment. Now, what circumstances the registered partition is one. The two circumstances. Reopening and petition can be reopened only clearness or excess of money in place. All other cannot be reopened. But in the present case, the period of unfairness, it made there was no issue about it. It has not been favored, it has not been proven because no evidence in the meaning of the people have been given up. After venture only issues are missing because it is not a
If the partition was inequitable, the whole partition has to be opened. It can't be in part.
But this is another question that so if the unfairness and inconvenience is low, question of limitation does not. In the present case, it has not been proved, no issue at all. No proper reasons are there. But in the present suit also, the judgment say, the thing of growth, he doesn't miss. But this is what's that? Suit was 500, 1975, 85, and when he attended with that, 5 months. So what they have filed are for 1985. 5 months for 2 months. But the conduct section also, it is stated that in the conduct section, the last date in Monac. The conduct section was suit arose in the year 1967. It about 1 week ago. Differences are 20% of the work to mother, 20 years of the week. But the only reasons which have been given are just on the ground of limitation also, court said that 151, the number 151.
Yes.
Issue of because partition it can set aside or it is a 133. It is 135.
Yes.
The third issue, whether the plaintiff, the partition deed between the defending husband of the reasons were again the level of the ground, the reason stated is that we pay 150.
Yes.
Plaintiff has specifically contended that the or if we enter into rendered into partition deed, in presence of partition deed, independent is allotted to multi, one of the other servant, that was survived.
Paragraph
Dependent 4, 5, 6, and 7, all put together and then writing. If the partition is rendered significantly, otherwise, then the partition US. Partition is also something that the benefit is what is good share, half share. What is an execution of the two right? After it, depending on same is average. There one could get independent. The range is monitor, your other content, there is other one of the independent, 14 services with the 9 certified. I want to share the things or a daily power of them, the thing is aware of the same, and bound by it, then it is not under the instead partition meaning valid in law and is not liable to service. The relevant document, expression of the issue under the consideration is the people. She is a the partition makers. So the maybe the said partition one of not the case. Your question 50 seconds in each of the so, in that distribution of the appears that there is illegal and also our main other body. So the revision portion so looking to the sense and cannot be a reality only on the ground that it appears the earlier partition is the weak one, report is valid. So the cheating, unfairness, influence, classroom and other is that no issue has been felt that only the thing cannot be the same. Next, the question of personal issue.
Yes.
These issues have remained nothing more for consideration. In the fact that the government is right. Regard to the property sold by the defendant, but in more of one times of 14, the self fact is admitted as a right given. It's also admitted that there is a debt that we have to show on the part of the defendant. We are aware of the extra part of the deed. So that debts that dependent on the court, the government put up report secrets. So in the view of the self fact, so the sentences under the consideration of given up to the therefore, I was working in the concern issue, maybe the issue of the court. So since you have given up, therefore the partition is significant. Next additional issue, there are limitations. This issue is also framed. Here the potential with consideration of the fact that the section 5 they are already
Yes.
But one more maybe. For now, the market remains is. How remain? You are. But Dattatriya alone will not take us. Sister, number of them, legal estate. It is. You of each one partition. These are generated. The errors of someone generated. This is it.
Yes. Or disturb mabidi vaga. Yes.
Without disclosing what without by own land related part. I have more eyes with the related part. They are mixed brothers.
No, but if that gentleman is given the larger share, because of which it is inequitable, he is the person who's got the largest share. Let us assume that it is for the purpose of clearing the debts. All right, but still, the persons who purchased would be bound by this inequitable partition. So they would, without there being a challenge to that, you are accepting the partition in half, saying that, all right, there was, forget about that now.
In the written statement, saying that for the purpose of protecting laws and reconstruction, we have not adopted. She denies in the
Whether she says it or not.
They are saying, because it's a registered document, we will accept that. So there is nowhere in partition deed. He was a minor, admittedly, he was a minor, the revenue of the body. He should have been protected there. He has been done.
Therefore, if that partition was bad, it was inequitable. How can that partition be upheld at your instance only in respect of one share and the partition be reopened in respect of all the other shares? How can you exclude 34 acres? No, who are you to exclude 34 acres which is alienated? Who are you? You are saying partition is bad. Either it's completely bad or it's not completely bad. It can't be half bad, it can't be half good.
She has also not stayed wrong.
Therefore, whatever was granted to the other side in excess of their entitlement should also have been the subject matter. Forget about what she has done. I'm asking you a direct question. What is the effect of you giving up that particular share? What is the effect of you giving up a challenge to that particular relation? Fourth wait today. Let us assume I am in your favor for partition, reopening the partition. Now, if I accept your argument, the partition will be reopened to the extent of division amongst three brothers, but alienation in favor of your biological father would still be valid. Isn't it? Doesn't care. It doesn't matter whether you lose it or not. You want a partition to be reopened in part. That is the effect, isn't it, Vidya? Forget about what they could have. You have come to the court. You are saying the partition was inequitable, was fraudulent because you were excluded. Correct. Therefore, the entire partition should go. This is a different argument, Vidya. This is a different argument. We're asking for reopening. It's just not a simple suit for partition.
What is maybe you?
It makes a world of a difference, isn't it? It makes a world of a difference. Your mother has been granted a share.
We can be about that. So this court has what's happened. What would that be? The word is maybe different. He might have said was reopened.
No, you attack the partition, isn't it? You attack that partition.
Yes.
Yes. If you attack the partition,
I'm not saying that have partition. It's a very cause of what I'm saying.
to the extent is allotted amongst your other people, except your biological. The prayer is to set aside. The prayer is to set aside the partition between the defendants 1, 2, 3 and husband of 4 defendant and the 8 defendant. Well, would rupees so and so, and thereafter for partition. So until the first prayer of partition is granted, you can't be granted the second prayer. ನೀವು ಆತರ ಹೇಳಿದ್ರೆ I am not bound by the partition deed. Whatever has happened under the partition has happened. I am entitled for my share. Please grant me my share. On the other hand, you set up the plea of an inequitable partition, which is required to be set aside.
For every sentence, he wants to say 30 acres have been 30 acres might have been for the one.
ನೀವು ಅದನ್ನ ಹಂಗೆ ಉಳಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ then you had a wonderful case. ಆ ಪ್ರೇಯರ್ ಹಂಗೆ ಇಟ್ಕೊಂಡಿದ್ರೆ you had a wonderful case. ಅದು ಬಿಟ್ಕೊಟ್ಟಿದ್ರೆ ನಿಮ್ಗೆ ತಪ್ಪಾಯ್ತು. ಅದರಿಂದನೇ ಕಷ್ಟ ಆಗ್ತದೆ. 8 ಎಕರೆ ಇದೆ ಬಿಡಿ ನಿಮ್ ತಾಯಿಗೆ ಅದ್ರಲ್ಲಿ ಬಂಗಾರ ಸಿಗುತ್ತಲ್ಲ. 4 ಎಕರೆ ನಿಮ್ಗೆ 4 ಎಕರೆ ಶಾಂಭವಿಗೆ. You are a good son of the family. You are agreeing for alienations being made to set off the debt of your family. So you have been an honorable person. 8 acres. Mother has not challenged it. Your mother.
She has not represented. Thereafter, she takes some share. The entire share is between.
ಒಳ್ಳೆ ಕೇಸ್ ಇತ್ತು. ಅದೊಂದು ಮಾಡಬಾರದಿತ್ತು. ನಿಮ್ ತಂದೆ ಜೊತೆ ಹೋಗಿದ್ರೆ ಆ ತಂದೆ ಹೋದಂದ್ರೆ ಈ ತಂದೆ ಜೊತೆ ಸೇರ್ಕೊಂಡಿದ್ದೀರಾ ಅಷ್ಟೇ ಆಗಿರೋದು. ಇನ್ನೇನು ಆಗಿಲ್ಲ. You have the advantage of having 2 fathers, a biological and adoptive father. Whenever you want, you can choose. Your loyalties are. No, but whatever your biological, or ಏನ್ ಮೋಸ ಮಾಡ್ರಿ you and you honor him by not challenging the soul. ನಿಮ್ ತಂಗಿ ನಿಮ್ಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ತಿಲ್ವಾ? ನಿಮ್ ತಂಗಿ ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಶಾಂಭವಿ. She is not supporting you. ಸುಮ್ಮನೆ ಇದ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವಳಿಗೂ ಕೊಡ್ಬೇಕಾಗತ್ ಭಾಗ, ಇನ್ನೂ ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ. You will get it now that your mother is dead. You will get 4 acres. Yaar, who's different number 3? Yaar, D3 yaar. Yaar, who's different number 3? The Veerudra Pranti. Different number 4. But then will establish agide. Will establish agidya? Matte bidi hanga. Challenge that request.
She has looked at the entire property. She, Saraswatama address, Savitrama is saying, we are taking care of. That is their case. Now, floods, they are taking care. Savitrama, that is so much they have contentment that we minded, they have kept fraud, certain issue, everything is.
Avil ಮೇಲೆ issue ಇಲ್ಲ ಅಲ್ವಾ? ನೀವು ಸಪರೇಟ್ ಆಗಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವಿಲ್.
This, I only naming my distribution.
Everybody, if you discount, if you the 30 acres it is granted to your biological father, everybody is given 8-9 acres. Nobody is given extra. And even according to your government, 30 acres was granted only because the family had incurred a lot of debts. So if you take away that particular share, it is equal. Everybody's got 9 acres or 8 acres. How can you say it is inequitable? Correct. No, for me to accept it is inequitable. That means one person should have got a huge benefit. ಎಲ್ಲರಿಗೂ ಸಮಾಗಿ ಬಂದಿದೆ, ಎಲ್ಲಾ ಬ್ರಾಂಚ್ಗೂ ಸಮಾಗಿ ಬಂದಿದೆ. ನಿಮ್ ಬ್ರಾಂಚ್ಗೂ ಬಂದಿದೆ. ನಿಮ್ ತಾಯಿ ನಿಮಗೆ ಮೋಸ ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ ತಾಯಿ ವಿಲ್ ಬರ್ಕೊಟ್ಟಿದ್ ಮೋಸ ಆಯ್ತು. You would have succeeded on that ground had you not given up that particular challenge to that particular elimination. Adilla andre that is a problem, because you give up, then you virtually killed your case by accepting the partition. Now that is the consequential prayer. Now it can't be the main prayer. Correct. ಅದಕ್ಕೆ ಹೇಳಿದ್ನಿ ಎಲ್ಲಾರ್ಗೂ ವಿದ್ಯಾ ಎಲ್ಲಾರ್ಗೂ 8 ಎಕರೆ ಬಂದಿದೆ. ನಿಮ್ ತಂದೆಗೆ 30 ಎಕರೆ ಕೊಟ್ಟಿದ್ರು. ಈ ಚೋಸ್ಟು ಅಲ್ಲ, ಬಯಾಲಜಿಕಲ್ ಫಾದರ್ ಕೊಟ್ಟಿದ್ರು. ಅವ್ರ ಪಾಪ ಮಾನಮರ್ಯಾದೆ, ಫ್ಯಾಮಿಲಿ ಮರ್ಯಾದೆ ಉಳಿಸೋದಕ್ಕೆ ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮರ್ಯಾದೆ ಉಳಿಸಿದಾರೆ. 30 ಎಕರೆನ ಮಾರ್ಬಿಟ್ಟು ಸಾಲಗಾರರನ್ನೆಲ್ಲ ಮುಗಿಸಿದ್ದಾರೆ. ಸೊ ಇನ್ನೆಲ್ಲರಿಗೂ ಏನ್ ಮಿಕ್ಕಿದ್ಯೋ ಸಮ ಹಂಚಿದೆ. ನಾಲ್ಕು ಬ್ರಾಂಚ್ ಶೇರ್ ಬರಲ್ಲ ಅಲ್ಲ, ಒಬ್ರಿಗೆ ಜಾಸ್ತಿ ಬರಂಗಿದ್ರೆ ಎಲ್ಲಾರು ಸಮಾಗ್ ತಗೊಂಡು ಇಲ್ಲ. ಇಲ್ಲ 30 ಎಕರೆ ಎಲ್ಲಾರು ಸೇರಿ ಹೋಯ್ತು ಅಂತ ಬಿಟ್ಬಿಟ್ರು. ನಮ್ಗೆ ಬರೋದೇ ಇಲ್ಲ, ಅದು ನಮ್ಗೆ ಯಾರಿಗೂ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಅಂತ. ನಿಮ್ಗೆ 15 ಎಕರೆ ಬಿಟ್ಕೊಡೋದಲ್ಲ, ಎಲ್ಲಾರು ಸೇರಿ 30 ಎಕರೆ ನಮ್ಗೆ ಇಲ್ವೇ ಇಲ್ಲ. ನಮ್ಗೆ ಇರೋದೇ 30 ಎಕರೆ. 30 ಎಕರೆ 4 ಭಾಗ ಮಾಡ್ಕೊಂಡಿದ್ವಿ. ಇಲ್ಲ ಬಟ್ ನೀವು ಒಪ್ಕೊಳ್ತಿರಲ್ಲ, ತುಂಬಾ ಸಾಲ ಆಯ್ತು, ಆದ್ರಿಂದ ಅವನಿಗೆ 30 ಎಕರೆ ಕೊಟ್ಟಿವಿ. therefore ಮಿಕ್ಕಿದೆಯಲ್ಲ ಅದು ಸಮವಾಗಿದೆ. Not necessarily. Shivapa's branch may agree with lesser share also. There is no hard and fast rule that, see, I can understand in the remaining 30 acres, one person is given 20 acres, the others are not given anything or given minuscule share. It is inequitable. But if the family as a whole agrees, this is all that remains, all of us will divide in this particular manner. That is not inequitable. ಅದು ಪಾರ್ಟಿಷನ್ ಡಿಗ್ರಿ ಆದ್ರೆ ಬಟ್ ಅವ್ರು ರಾಜಿ ಮಾಡ್ಕೊಂಡು ನಾವ್ ಹಿಂಗ್ ಭಾಗ ಮಾಡ್ಕೊಳ್ತೀವಿ ನಾವು ಕಮ್ಮಿ ತಗೊಳ್ತೀವಿ ಅಂತ ಒಪ್ಕೊಳಂಗಿದ್ರೆ there's nothing that anybody can do about it. It's open for them to ask for the that is why that giving up of that allotment, challenge to allotment to your biological father plays a significant role. Although it changes the entire complexion. Nan prakara adu I'll consider. If there's a decrease, if the decree for partition by meets and bounds, what you say is correct.
They were jointly, prior to our Patta was which event?
Yeah, I would have been with you directly without, I wouldn't have allowed him to argue. If you had not given up that step, that giving up is killing your case. ಅದು ಈ ತರ ಮಾಡಕ್ಕಾಗಲ್ಲ ವಿದ್ಯೆ ನೀನು ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಆಯ್ತು ಅದನ್ನ ಅದು ಕಣ್ಮುಚ್ಕೊಂಡ್ಬಿಡಿ ಮಿಕ್ಕಿದಕ್ಕೆ ಮಾತ್ರ ಕಣ್ ತೆಗಿರಿ ಅನ್ನೋದು ಅದು ನೀವ್ ಹೇಳ್ತಿರೋದು.
I can understand it. Doctor matter show up and taken those cover. He had taken more. He had created that. And if that property was in the marriage, how this is reacted. I would have that is not the case. They say now what you married or something.
ಒಟ್ಟಿಗಿದ್ರಲ್ಲ ಸೊ ಎಲ್ಲಾರು ಒಟ್ಟಿಗೆ ಸಾಲ ಮಾಡಿ. I am not impressed with that argument.
With regard to limitation, because you can able to show unfair living. I have not been given legitimate share. I was in that. That's my that. And my interest has not been taken care of. It can be used anymore. So when fraud is concerned,
In fraud pleading, what is the pleading? What is the pleading?
they have played fraud.
ಅಲ್ಲ fraud plead ತರ ಮಾಡ್ಬೇಕಲ್ಲ. No. What is the plea first regarding fraud? Let us read the plea. You see, CPSL ಬರೀ ಅಷ್ಟೇ ಹೇಳಿದ್ರೆ ಸಾಕ ಇಲ್ಲ fraud. No, is there a requirement of a plea or not regarding fraud? What is the kind of plea that is required for a fraud? Does your pleading satisfy those requirements? ನೋಡಿ ನಾನು ಕ್ವೆಶ್ಚನ್ ಗೆ ಆನ್ಸರ್ ಮಾಡ್ತಿಲ್ಲ. From the pleadings that ಇಲ್ಲ. What is the pleading regarding fraud? Which paragraph? ಏನು ಫ್ರಾಡ್ ಬಗ್ಗೆ ಏನು ಇಲ್ವೇ ಇಲ್ವಲ್ಲ. ನಾನು ಹೇಳ್ದೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬಿಡಿ ನೀವು ವಿದ್ಯಾ ಕೋಪ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಮೇಲೆ Vera?
Pay the 100%. And therefore take inquiry.
ಏನು ಅದ್ರ ಮೇಲೆ ಪ್ಲೀಡಿಂಗ್ anything ಇಲ್ಲ, ಫ್ರಾಡ್ ಅಂತ ಎಲ್ಲೂ ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲ. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನೋಡಿ, ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಫ್ರಾಡ್ ಇದೆಯಾ? ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಫ್ರಾಡ್ ಇದೆಯಲ್ಲ ತೋರಿಸಿ.
Then, yeah. Land.
ಫ್ರಾಡ್ ಅಂತೂ ನೀವೇನು ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲ. ಫ್ರಾಡ್ ಅನ್ಡ್ಯೂ ಇನ್ಫ್ಲುಯೆನ್ಸ್ ಅದು ಇವಾಗ ಆರ್ಡರ್ 614 ಪ್ರಕಾರ ಬರಲ್ಲ ಅದು. ಫಸ್ಟ್ ಲೀಡಿಂಗ್ ಅಲ್ಲಂತೂ ಇರ್ಲೇಬೇಕು. ಅವ್ರ ಹೌ ವಿಲ್ ದೇ ಮೀಟ್ ದಟ್? ಇನ್ಫರೆನ್ಸ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ವಿದ್ಯಾ? ಕೆನ್ ಯು ಇಂಪ್ಲೈ ಫ್ರಾಡ್? You want an inference to be drawn without that pleading. Fraud. Correct. That material should have been first alleged, and that should be established. It's not on a question of. See, the partition does not become bad because of that. When you set up the plea of fraud or undue influence on your mother, you should specifically state in what manner she was defrauded. Very fact, but your mother's conduct towards you is unfair. That is not a pleading or a requirement of fraud or undue influence vis-a-vis the partition deed.
Partition deed is the very fact that I am excluded. I am excluded. My request ought to have been protected. I should have been represented. Why not represented by a yes? This is right. In spite of that, that they have paid. This behavior is sufficient to stop that they have paid fraud on misrepresentation. Nowhere must identity. That is the mother. She bequeaths the entire property.
That is not challenged by you, therefore it's of no consequence. If you challenge that in the alternative, saying that she could not have bequeathed my share, that bequest is not discriminatory suit at all.
But my legitimate share.
But you should, when there's a bequest, you should say that the bequest is invalid because of various reasons. Nothing prevented you. Separate. I will not say anything about it. File a separate suit if you want. I'll consider it. Chana?
Just been relied on.
Shalva. They don't dispute it. They are ಒಳ್ಳೆದಾಯ್ತಲ್ಲ at least ಈ ವ್ಯಾಜ್ಯ ಆಗಿದ್ದಕ್ಕೆ they accept that you are the adopted son.
Presenting LRs of
LRs of
respond number 2, my lords, Naglingachar, the original defendant number 1.
You are supporting the plaintiff or the defendant? Is he supporting you?
Defendants, my lords. My lords, the registered partition deed dated 9/5/1975 requires to be upheld and given effect to, whereby virtually equitable 8 acres of land being.
All right.
Please. Suit requires to be dismissed, please.
The facts that could be discerned from the proceedings are as follows. The genealogy of the family is as under given. The adopted son of Shivappa and Savitramma, that is Dattatreya, filed the suit seeking for setting aside the partition effected amongst his family members on 9/5/75 and for partition and allotment of his share in relation to the suit properties. As could be seen from the genealogy, Dattatreya was the son of Mannappa, who had been given in adoption to Mannappa's paternal uncle, Shivappa and Savitramma. The adoption was effected through a registered partition deed, registered adoption deed dated 25/3/1967. By virtue of the fact that the adoption was by means of a registered instrument, the same cannot be questioned and will have to be accepted. It was a case of Dattatreya that the partition effected on 2/9/5/75 could not be sustained as it was entered into in his absence when he was a minor, and more importantly that it was inequitable. Dattatreya contended that since the partition was inequitable, the same had to be set aside and the properties ought to be partitioned, in which event he was entitled to half of the suit properties by virtue of being the only son of Shivappa and Savitramma. The case of the defendants, that is the branch of Sharbanna, was that there was a registered partition deed. That registered partition had been entered into on 9/5/75. 9/5/75. In the background of the fact that there was large debts in the family, and in order to discharge this debt, out of the 65 acres of land, approximately 65 acres of land, 29 acres had been allotted to Mannappa. About approximately 29 acres was allotted to Mannappa, the biological father of Dattatreya. And the remaining 3 branches of Sharbanna, that is Nangalingappa, Narayanappa, and were granted approximately the same extent of 8-9 acres. And therefore, it could not be contended that the partition was inequitable. It is their contention that Mannappa, who was allotted the bulk of the property, that is nearly 50% of the property, had sold the entire extent. And Dattatreya, despite being aware of the fact that his biological father Mannappa had been allotted 50% of his new property, which he had chosen to alienate, chose to accept the alienation according to the 3 branches of Sharbanna, by acceptance of the allotment to Mannappa and the consequential alienations made by Mannappa, Dattatreya was essentially giving up the claim for reopening the partition, because Dattatreya could not have put forward the plea that the partition deed, insofar as it related to allotment to his biological father, was just, and only the partition effected amongst the other sharers under the partition deed was unjust. It is therefore contended that the decree of the trial court and as well as the appellate court, it is also contended that it is not in dispute that even according to Dattatreya, he was born on 2/2/64, and he would thus have attained majority on 2/2/82, and would therefore have had to file the suit on or before 2/2/85. But since the suit has been filed on 23/7/85, the same was barred by limitation. It is therefore contended by the 3 branches of Sharbanna that the trial court as well as the appellate court had erred in coming to the conclusion that the decree, that the partition effected was inequitable and was required to be set aside, and a partition by meets and bounds in which the branch of Shivappa was to be granted half a share was wholly incorrect. This court admitted the appeal to consider the following section question of law. The essential plea of Dattatreya was that the partition dated 2/95/75 could not be accepted since the same had been entered into behind his back and it was inequitable. In order to come to the that the partition was inequitable, the relevant admitted facts would have to be considered. As noticed above, under the partition of the year 75, the three branches of Sharbanna were granted 8 to 9 acres of land. The biological father of Dattatreya, that is Mannappa, who also represented a branch of Sharbanna, was granted the lion's share of nearly 30 acres. In this partition deed, which is not in dispute, there is a clear recital that he was being allotted the lion's share of 29 acres to enable him to meet the discharge the debts that the family had incurred. It is also to be noticed that Dattatreya's branch, that is his father Shivappa's branch, being represented by his mother, was also allotted 8 acres, which is more or less the same as had been granted to the other sharers under the partition deed. Thus, if the portion allotted to Mannappa, the biological father of Dattatreya, is excluded, all the other sharers would more or less get the same extent of land under the partition. Cannot therefore be contended that the partition per se was inequitable. Srimati Vidya Sayer, however, on the other hand, contended that Dattatreya would be entitled to succeed to half of 65 acres. That is nearly 32 acres. And assuming that his father was also liable to be the extent of 15 acres towards discharge of the loans, that would still leave an extent of 15 acres to the share of Shivappa. But despite this, only about 8 acres was granted to his mother. And therefore, the partition was completely inequitable. Next paragraph. It is to be noticed here that when the partition was effected, according to the abatements in the partition deed, the family was reeling under huge debts that had been incurred by the family. In such a situation, if all the persons who were entitled to a share agreed to take a common extent and keep apart 50% of the lands for discharge of the debts, it cannot be said that the partition was in any way inequitable. Next paragraph. Though arguments were advanced that the partition deed was vitiated due to the undue influence and fraud that had been played on Dattatreya's mother Savitrama, there is neither a plea nor evidence to support this claim. In order to succeed on a plea of fraud or undue influence, Order 6, Rule 4 makes it mandatory for the plea and the items of fraud or undue influence to be precisely stated. Merely making an allegation that the partition deed was obtained by fraud or by playing or by undue influence cannot be accepted. It is also to be noticed here that no doubt Dattatreya was a minor when the minor aged about 8 years when the partition was effected in 1975. He attained majority in the year 1982 and thus had 3 years time to institute the suit, that is on or before 2/2/85. However, he has chosen to file the suit on 23/7/85, which would thus bar his suit itself. Even if this element is ignored, the fact that Dattatreya accepted the partition insofar as it related to allotment of half of the property to his biological father and chose to restrict his challenge only to the remaining portion is concerned, virtually dissented him from seeking for reopening of the partition. If a partition is to be reopened, it would have been reopened in its entirety, and it cannot be reopened in part on the ground that it is iniquity. In this view of the matter, in my view, the judgment and decree of the trial court granting reopening of partition and for ordering a fresh partition cannot be sustained. The question of law is accordingly is answered, holding that Dattatreya could not have sought for reopening of the partition effected on 9/5/75 under registered partition deed, to which his adoptive mother was a party, on the ground that it was inequitable or unfair. It is also to be noticed here that Dattatreya's mother not only participated in the partition, but was also granted the same extent of 8 acres. Thus, the branch of Dattatreya's father was granted the same as the other 3 branches. Line Mural. There are 3 branches of Sharbanna. Here, that as had been granted to the 3 branches of Sharbanna, excluding Mannappa. If the mother of Dattatreya chose to accept this partition and did not challenge the same, the adopted son cannot be permitted to challenge the same nearly 10 years after it had been entered into. Question of law is therefore answered accordingly. Second appeal is allowed. Suit of Dattatreya is dismissed. Is set aside. Then at counsel for Srimati Vidya Iyer relied upon removed judgment. No, Sarish Kumar. Relied upon the judgments rendered by this court in 2025 cases here. 2000. Comment. Counsel for the appellant sought to place reliance on the judgment rendered by the Supreme Court. Rendered in the case of AB Papaya Shastri and others versus government of AP. Yeah, paragraph. to contend that a judgment, decree, or order obtained by fraud is a nullity and would have to be treated as a nullity. According to her, the partition deed was obtained by fraud. And applying the said principle, it will have to be held that the partition deed was a nullity. As noticed above, there's neither a plea of fraud nor any evidence to support her contention that the partition deed was obtained by fraud. As already stated above, in order to succeed on a plea of fraud, the necessary ingredients were to be clearly mentioned in the plaint, and those averments will have to be established with satisfactory proof. Since neither of them have been done, the said decision would be of no application. Amala? ಯಾವ್ದು ಹೇಳಿ? She also sought to place reliance on 1976 1 SCR page to contend that there was no question of applying the law of limitation in relation to a proceeding which had been initiated for reopening of the partition. ಯಾವ್ದ್ರಲ್ಲಿ ಈ ಅಲ್ಲ? ಅಲ್ಲ, ಇದರಲ್ಲಿ ಯಾವ್ದು ಹೇಳಿ? ಎಲ್ಲಿದೆ?
The consideration of authority of dismissal following their consent cannot unless it is shown that the same is
The limitation.
the partition is effective. However, partition effective. That's so further. We adjust it unfair.
To contend that a partition can be reopened without reference to time. It is to be noticed here that the Supreme Court in the said case has stated that a partition can be reopened if it is found to be unjust and unfair without reference to time. However, Dattatreya has failed to establish that the partition effected between his mother and his uncles was unfair. As already stated above, his biological father was granted 30 acres and his mother and his uncles were granted virtually the same extent. And this proves that there was no unfairness in dividing the properties after setting aside land for discharge of the debts. This decision therefore also has no application. The other two judgments relied upon, that is 2025 KCCR and RSA 50 of 2014, would also have no application since they merely rely upon the proposition laid down in Ratnam Chettiyar's case. Repetition, Anna. ಬೇಜಾರ್ ಮಾಡ್ಬಿಡಿ ನೀವು. ತುಂಬಾ ಕೋಪ ಬರ್ಸ್ತೀರ ನೀವು ಅವ್ರಿಗೆ.
where it says.
Next read. The petitioner herein is representing the branch of Dattatreya, na?
50% of the amount you release it in their favor. So for a Dattatreya, it is a disposal. After starting that stay was granted by the Supreme. Now staying is there in this. The other great question is, deputy three months have been dismissed. Second of it has been dismissed on the ground that land has been acquired.
Now that the RSA is dismissed, red petition, there's no need. Only if you have a decree, the question of FDP. If you have no decree, then no question of FDP. Yeah. Idru ಅಷ್ಟೇ ನಿಮ್ ಶೇರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಿ ನಿಮ್ ತಾಯಿಶ್ ಅಲ್ಲ ನನ್ನ ಪ್ರಕಾರ ನಾನ್ ಫೈನಲ್ ತಾನೇ WP ಕೊಡಿ. This writ petition is filed challenging annex ಸರಿ ಅಲ್ವಾ? Challenging the order passed by the final decree court, by which the application filed to drop the final decree has been dismissed. In view of the fact that the suit filed with Dattatreya seeking for reopening of the partition and for consequential partition has been dismissed today by a separate order passed in arrest number so and so. This order does not deserve to be interfered with, and consequently the petition is dismissed as and become unnecessary. WP 106930/31. In this writ petition, annexure F, endorsement issued by the KADB permitting to withdraw 50% of the amount, 50% of the compensation amount, and a direction not to disperse any sum to Dattatreya is called in question. In view of the pendency of RSA 5359/2012. Since by a separate order, RSA 5359/2012 has been allowed today, and the suit filed by Dattatreya has been dismissed. The impugned order directing dispersal of compensation to the respondents cannot be called in question by Dattatreya. The petition is therefore dismissed. ಶಿವಪ್ಪನ್ ಅವ್ರ ಬ್ರಾಂಚ್ ಸಾವಿತ್ರಮ್ಮ ನಾನು ಹೇಳಿದ್ದು ಕರೆಕ್ಟ್. ಶರ್ಬಣ್ಣನ್ 3 ಬ್ರಾಂಚ್. ನಾನು ಹೇಳ್ತಿರೋದು ಶರ್ಬಣ್ಣನ್ 3 ಬ್ರಾಂಚ್ ಅಂತ. 4 ಬ್ರಾಂಚ್ ಶರ್ಬಣ್ಣನ್ಗೆ 4 ಶೇರ್ಸ್. ಶರ್ಬಣ್ಣಂದು ಶಿವಪ್ಪಂದು ಅರ್ಧ. But Sharbanan branch ಅಲ್ಲಿ there were 4. 1 got a larger share, 3 got a lesser share ಅಂತ. That's my intent. ನೀವು ಏನ್ ಬರ್ದಿರೋ ಅದನ್ನೇ ಹೇಳಿದ್ರು. So the suit is dismissed. Judgment of the trial court and the appellate court are set aside. The suit is dismissed.
Passed over matter, case number 1. Case number 3, again Jagdish.
On 2/8/2022, the matter was adjourned on payment of cost of this 500. The matter was posted in that day since the cost date was not amended. And the counsel for the appellant remained absent. Till this day, neither the cost has been amended nor proof of having paid the costs has been produced. It's obvious that the appellant is not interested in prosecuting the appeal. Consequently, the appeal is dismissed on prosecution. In 2018, there appears to be one ruling which says until you pay the court fee, there is no institution of the appeal at all. So there will be a delay. Why do you want to take that risk? Finally, a week's time is granted to comply with the office objections. If the office objection not complied with within a week, the appeal would be dismissed without reference to the bench. 1 week, if you don't come, next Monday. 8th, 8th, 7th, 8th.